Chief Justice, may I take 1 minute of your time?
Yes, Dr.
Your Lordship wanted a list of the non-legislative functions of the state legislatures.
Yes.
Of course, the most important is democratic accountability. That's what the freedom movement was all about. From representative to responsible government. I made a note. Shall I pass it on and have it uploaded?
On what are the non-legislative functions? All right, because that was a question of the court, you can certainly.
Because that's the question.
Yes.
From your
Upload.
Can I hand it over?
Yes. Put it as part of Mr. Yeah, can you ask a junior to email it, Dr. Dhawan, to the court master?
We'll do that. I'm obliged.
Give it to Mr. Prasanna and he will upload it.
All right, no difficulty.
Along with the excerpts of
All
some of the judges.
All right, thank you, Mr. Jaffer.
But proceeding on the premise that lordships have gone through the
Yes.
submission, there is one apology that I have to make, not but there is one serious error in that written submission. But wherever I have referred to Jammu and Kashmir, please read merger as accession, not merger, because lordship has seen Kashmir did not merge. So that's the error which I have committed. I want to rectify it. Wherever I use the word in my written submission, merger in respect of Jammu and Kashmir, it has to be accession. Now, Lord, I'll take just 2 minutes to sum up the context part which the lordships must have seen. Kashmir, Lord, acceded differently because it acceded post August 47. The rest of the states concluded their accession as well as standstill agreement before August 47. Because standstill agreement was a precondition for instrument of accession. So they had all signed. Kashmir did not do it. And therefore, as per the cabinet mission memorandum 25th May, as well as the India Independence Act 1947, section 6 and 7 and 8, Kashmir acquired independence because the paramountcy ceased on 15th of August 47. That's the crux of the cabinet mission memorandum and the India Independence Act that follows it.
Yes.
The rest of the states barring Kashmir merged through agreements, from time to time, with the Dominion of India, ceding all their powers and sovereignty, barring Kashmir. And that is what Lordship would notice in the instrument of accession. I would not take Lordships through it, but that is what Lordships notice. All the states, unqualified cession of sovereignty to the Dominion of India. Some ceded not directly to Dominion of India states, larger ones. Some ceded the Dominion of India while they merged with the provinces. Provinces, Lordship would know about the provinces under the Government of India Act, and they automatically merged in the Dominion of India. And some ceded to the Federation of States, the Union of States. But eventually, all these ceding rulers and states, Indian states, they accepted that their right to make constitution, which was guaranteed to them in the cabinet mission memorandum, and thereafter under the India Independence Act and the negotiations. They all ceded that Constitution of India will now be the sole constitution, with their constitution merging in the Constitution of India. And that is what is not the genesis of Article 238. Article 238 is significant, Lord, and this will answer one of your Lordship's query, Lord, that what was the status of Kashmir when it ceded to the Dominion under Article 1 and the schedule.
Where will we get Article 238 actually? Where will we get the, because our constitution copy doesn't carry it. So if, I'll just check.
Not that.
It doesn't have in this, yes. I'll share it with Justice Court. Is it anywhere in the compilations? In the compilations, do we have it somewhere?
I have copies of this. In fact, I brought copies of the.
Anyway, no, don't worry. We have it here.
You all rely heavily on Mr. Shankar. So very adept at these things.
Will
We are
the
not.
constitution as applicable to the state of J&K have that?
I'm sorry, no?
Will the constitution as applicable to the state of J&K have that? No.
No,
No, 238 is in the Constitution of India.
and it
So-
can't have it because it's barred.
Yes, that's fine.
No, I'm coming to that.
E of the first.
I'm coming to that as a slight, something to be said. Lordships would bear this in mind that Kashmir ceded and became part of Union of India as Part B state. And all the ruler states were part of Part B state. I mean, they were all Part B in the schedule, first schedule. And therefore, 238 was made applicable to Part B states only, which were Indian states. Only what 238 does was, it keeps the promise of applying the state's constitution to the government, to the union, the Constitution of India. Part B state, 238 says that Part 6, 7, and consequently Part 11 will also apply to these Part B states. And that is how not all these Indian states merged unconditionally into the Constitution of India. Initially, all the Indian states were promised that they will have their constitution. But then through negotiations, this was taken out. My old vision.
Yes.
Now, the status of therefore Kashmir was of a Part B state in the year 1950 when the constitution was enacted. And yet, Lordship would notice in 370, Article 238 was excluded. That speaks volumes about the autonomy of the state.
Yes.
Therefore,
Just hand these up,
Are these given on a returnable basis or on a non-returnable basis?
That's what I got. In fact, when we were arguing Boileau's matter, we were looking for Article 31 and it wasn't in the footnotes. So when we conceived this constitution, we had to put all the old provisions. So
but the only discrimination my friend has made is I have been demoted.
You want me to have a later edition of this?
it's coming out in 3 days.
But the original, the intention to gift me was not there.
Attorney is very upset that attorney is being discriminated against.
No, you have mine, I have one.
Copy, I can
Um,
return it with my own copy.
Brother has his own copy.
I
So.
have my copy.
No, the Tony should be penalized for gifting us all. Now coming back to the number of this brief introduction was necessary because the basic theme of ours is that the Kashmir was entirely different, and this is what Lordship would notice in the debates.
It's all vanity, no fun, your losses.
Kashmir was different, both in respect of accession to Dominion of India when it ceded at a different point of time as an independent state or a nation. And it was different in the sense that it did not merge, unlike the other states, its sovereignty. And that is why the Lordship would notice in the instrument of accession, which was negotiated by Kashmir, the ruler. There are a couple of clauses which are not there in the other instruments of accession. Format is the same under 1936 Government of 35 Government of India Act, but the conditions which were added in favor of Kashmir were not there. For instance, we are not bound by any provision of the Constitution of India, future Constitution of India. The internal sovereignty rests in the ruler. The Union of India cannot acquire land in Kashmir. Kashmir would acquire for Union of India and give it. Now, from here, noticing these important issues, Your Lordships may just, I'd like to answer Lordship's query, which fell from my Lord the Chief Justice. The sovereignty aspect. And which eventually will answer Lord Justice Khanna's query also, the superior and inferior constitutions. Eventually. Now, the first aspect that we have to keep in mind is, his sovereignty was retained by the Raja in the instrument of accession. Lordship has seen that, so I would not waste Lordship's time. The concept of sovereignty is a variable concept, Lord. Concept what it was in the 19th century, 18th century was no longer there in the 20th and 21st century. When the written constitution started and the democratization of autonomy, as my friend puts it, that's a very phrase pregnant with meaning. Democratization of authority and power, which is autonomy. His sovereignty being a variable factor has two components, the internal and the external, and there are two decisions which Lordship may just care to note. One is 1953. 1953, PEPSU, PEPSU, full bench, which deals with a similar situation where Patiala as an estate merged with British paramountcy. Then what was the position of sovereignty of the Raja?
The page, Mr. Dwivedi?
Page 730. 14, please listen to what I'm saying. Please listen.
You can give us page later, no problem. You can just have it.
739. 739.
739. What is the principle which it lays down?
I'm sorry, there is some 1953 PEPSU 1. But I'm sorry, this confusion arises.
No.
It's AIA.
Yeah.
Is it in any compilation?
Yes,
Case law compilation?
Yes. Which says the sovereignty comprises of two parts. Mainly because you have ceded external sovereignty, defense, external affairs, and communication, it would not amount to ceding of internal sovereignty.
And what is the second judgment?
The second judgment, Lord, is a recent judgment, 2000, volume 8, SCC 61.
You repeat the citation, please.
2000, volume 8, SCC, page 61, paragraph 31 and 2.
Paragraph?
31 and 2. 31 and 30.
And where was this in the compilation? Where did you get it?
But I'm sorry, it's not there in the compilation because
It's easy
later
to get.
research not yielded all these results.
Page 61.
I've given the paragraph. And I don't have time. And the third judgment in this regard, which is a clear pointer towards where the sovereignty rests post-constitution, not the internal sovereignty, that is 59 Supreme Court, PN call.
KR 59 Supreme Court? Or?
PN calls case. No?
Oh, yes. That is case law compilation.
Page, volume 1, page 8. PDF page 8.
We have seen that, yes.
That's the situation with regard to sovereignty. You know? It's not that the Kashmir lost all sovereignty merely because it acceded. And neither inclusion in the Article 1 and the schedule would result in losses, not internal sovereignty. Now, Lord, the key part of my argument is based on, and the key question which I am raising is, that Article 370 ceases to operate once the Constitution of Jammu and Kashmir was enacted on 26th of January 1957. Now, it is somewhat different from what most of my friends have argued. They want some part of 370 to survive post 57. My argument is nothing survives. All the powers conferred under Article 370, I would show would cease to operate once the Constitution is enacted. And in that context, we have to keep in mind the object of 370 and the commitments made by the Dominion of India then, and the approval of those commitments by the framers. But we must bear in mind that the people governing Dominion of India were mostly the same who were the framers of our Constitution. And they were wise men. We always say framers were most wise, dynamic, and sagacious. But then when it comes to the commitment made by them, Lord, we forget their sagacity. And therefore, I would pray, please permit me to place the debate, Lord, of Dr. Iyengar, Lord, that is most crucial for my argument, and juxtapose it with 370, Lord, then I'll show one by one, Lord, all of the provisions become otious. So this is something which is a must for my argument, and I'll pray, please permit me.
Instead of reading, us reading now Mr. Iyengar's
Debate.
debate, his address, because we've read it 3 or 4 times. If you can cull out, and we'll take it down, if you can cull out what are the key parts of what he said, so that and then we'll go on to 370.
Lord, the debate, if Lordship will see, the initial part says that Article 370, Clause 1, B1 and 2, these are provisions providing for consultation and concurrence of the government of Jammu and Kashmir. And it clearly says, debates clearly say, that this was an interim arrangement till the Constituent Assembly was constituted. Now, what does, with due respect, I submit not ask myself, what does this interim arrangement mean in respect of 1B1 and 2? If it was an interim arrangement, they said it is interim vis-a-vis clause 2, which says as soon as the Constituent Assembly comes into being, the final decision is that of the Constituent Assembly. With regard to A, the jurisdiction of Union and Parliament over Kashmir, and the Union's relations with the state, or state's relation, conversely, the state's relation with the Union.
So the first is jurisdiction of Union of India over Jammu and Kashmir. And second,
I'm sorry, but I can.
you said once the Constitution of J&K comes into being, the final decision
Is that of the Constituent Assembly of Jammu and Kashmir, which was formed for framing of the Constitution. Clause 2 says
on 2 aspects, you said. One, jurisdiction of Union of India over Jammu and Kashmir.
and the center and the state relations. The finality would be that imparted by the Constituent Assembly of Jammu and Kashmir. I'll place only those portions not from the debate which not unerringly lead to that.
All right, let's quickly see those.
Yeah.
If you can just give us the page reference. वो अपना जो laminated दे दीजिए जरा.
Kindly come to note volume 5, PDF page 79. I'm reading note
Volume 5, page 79.
Not I'm reading the internal page 424.
We'll just go to that in a second.
Have lots of contact.
Just 1 second.
किसने पाना?
Relax.
What is the page?
That is volume
Now,
5,
the
page
first part-
79. You're on the right document, but volume page 79.
The first part, of course, deals with the different situation of Kashmir, which resulted in this discriminatory treatment of Kashmir in favor of Kashmir. Then kindly come to the last paragraph. Last paragraph of that very page, no? Again, the passage begins like this, no? Again, the government of India have committed themselves to the people of Kashmir in certain respects. They have committed themselves to the position that an opportunity would be given to the people of the state to decide for themselves whether they will remain with the republic or wish to go out of it. That was the extent of right given. But let's keep that aside for a moment. Then last three lines of the paragraph, last 4 minutes. We have also agreed that the will of the people through the instrument of a constituent assembly will determine the constitution of the state as well as the sphere of union jurisdiction over the state. That's a very clear indicator. Sphere of union jurisdiction over the state will be determined by the constituent assembly. Now, lordships have gone through it, my friends skipped through it, but then the important aspects have remained uncovered. Therefore, I was. Then kindly come to the next paragraph, which is even more significant. And this represents clause 1B1 and 2. At present, the legislature, which was known as Praja Sabha in the state, is dead because the situation was such in Kashmir at that point of time, nothing could be functional. Neither that legislature nor the Constituent Assembly can be convoked or can function until complete peace comes to prevail in that state. We have therefore to deal with the government of the state, which as a representative, as represented in its council or of ministers, reflects the opinion of the largest political party in the state. Till the Constituent Assembly comes into being, only an interim arrangement is possible and not an arrangement which could be brought into line with the arrangement that exists in case of other states. Now, the word interim arrangement follows their elaboration that neither the Constituent Assembly is convoked nor the Legislative Assembly is there under the 39 Constitution, which is Praja Sabha. Therefore, whom should we consult? We are forced to consult or get the concurrence of the government, which is the only representative body, till the Constituent Assembly comes. This leaves no room for doubt. With regard to 1B1, 1B2, and even 1D, I'll show. all those provisions which provided for consultation and concurrence with the government of India, government of Kashmir, cease to operate operate only till the Constituent Assembly is not there. No sooner it comes into being, they cease to. Then, Lord, the next paragraph, which is a short paragraph, further corroborates that impression. And it further indicates that 306A is also a temporary provision. Not all this argument, Lord, that has become permanent. We are giving meaning to the word temporary used in the constitutional provision. What's the context, the object? Please have this. Now, if you remember the viewpoints that I have mentioned, it is an inevitable conclusion that at the present moment, we could establish only an interim system. 306A is an attempt to establish such a system. Now, what else does temporary provision mean? It's an interim provision. They're saying it in so many words. And yet, what we are trying to do is make it permanent, changing the entire text of the Constitution. No, 306 Lordships, no. Sure, I mean, sorry. for a second, no? The Constituent Assembly is always regarded by us as the most august assembly ever in the history of our assembly, and they evolved the Constitution. They were men who fully knew what Constitution means. When they say, you know, the Kashmir would frame its own constitution, they could have not implied anything else except what they were doing.
All right, we now take this point of yours based on those two extracts from
Right.
Mr. Gopal Swami Iyengar's speech. Now, you still want to refer to further something here in his speech?
Yes.
All right.
Kindly have not omit the next paragraph, Lord, that is 238, so I've already elaborated. So,
Yes.
Then come not to the next one, not the paragraph. The second portion of this article relates to the legislative authority of Parliament over the Jammu and Kashmir state. This is governed primarily by the instrument of accession. Broadly speaking, that legislative power is confined to three subjects of defense, foreign affairs, and communication. But as a matter of fact, these broad categories include a number of items which are listed in the instrument of accession. I believe they number some 20 to 25. Now, these items have undergone a change in the description, in numbering, in arrangement as amongst themselves in list 1 and list 3. But this is the justification of putting list 3 in 371B. Now, these items, no, I'm sorry, it is therefore necessary that the items mentioned in the instrument of taxation should be brought into line with the changed designation of the entries in list 1 and 3 of the new constitution. So clause 1B of article 306A says that this listing of the item as per the terms of the new constitution should be done by the president in consultation with the government of the state. Then kindly come to clause B2, that is for concurrence. Clause B2 refers to possible additions to the list in the instrument of accession, and these additions could be made according to the provisions of this article with the concurrence of the government of the state. The idea is that even before the Constituent Assembly meets, kindly notice again the same thing comes. The idea is that even before the Constituent Assembly meets, it may be necessary in the interest of both the center and the state that certain items which are not included in the instrument of accession would be appropriately added to the list in that instrument so that administration, legislation, and executive action might be furthered. And as this may happen before the Constituent Assembly meets, the only authority from whom we can get consent for the addition is the government of the state. Now, if I will not read this and if I draw an inference from this, the only inference is that even B2, for all those provisions where concurrence is required of the government or consultation is required of the government, or adding anything to the instrument of accession, whether in terms of list items or in terms of other provisions. All the provisions of consultation and concurrence were in terrain till the Constituent Assembly meets. This
Kaveri, just also read the next clause. The
Aye.
last clause refers to. And thus the Constituent Assembly, when it is referred to in the last sentence of that clause, is
Yeah,
an indication that the Constituent
is
Assembly
reading.
may continue. It's at page 427, internal page.
No, I'll come to that. Please bear with me. No, I'll explain that also. I'll explain. I have that in mind. I'll bear.
And whether the Constituent Assembly, when used in the last sentence of that paragraph,
Yes.
will be in the indication that
Even
probably,
is in our favor.
probably the Constituent Assembly over here was meant to get prolonged also.
I'll answer that. Then having seen this, no, that the consultation and concurrence were only for a temporary period till the Constituent Assembly comes into being. And that is what Lordship may now fall back on the Article 370 Clause 2. Clause 2. No, but this submission of mine tends to show to your lordship's note that both the provisos again provide for consultation and concurrence. Because they govern clause 1B to 1D. And therefore, no sooner the Constituent Assembly, as per the intent of the framers, comes into being, they would continue to operate because that's the only agency left for consultation and concurrence. But once it comes, then the consultation and concurrence has to be with the Constituent Assembly. That is what clause 2 says.
Mr. Dwivedi, I don't want to rush you. We started at 10:40 today. The time allotted to you is till 11:25. We are now about 11:12. So you'll have to, everybody will have to stick to time today. So
Lord, I'm obliged, Lord, Lordship has granted me this much of time, but please bear in mind, if I'm saying something which has already been said, Lordship may stop me. But if there's something which perhaps is new or different.
all that I'm saying is we need not read now the rest of Mr. Iyengar.
Not. No. But the Iyengar statement is relevant because it answers Lordship's query as well as not the inferiority and superiority of the Constitution of India. Also, I'm sure.
That
So
speech we
according
have read
to-
at least twice, thrice.
I will.
That speech we have read at least twice, thrice before.
But your contention really is that once the Constitution of Jammu and Kashmir was framed on 26th of January 1957, the entirety of 370 ceases to exist.
There's nothing left now.
And then the only governing document is the Constitution of Jammu and Kashmir. We got the point because they'll have to answer that.
We cannot ignore the fact what was the commitment made. Lord,
That
when
was
we
the
see 370, it has to be in the light of the commitment made to the
Now,
people of Kashmir.
Mr. Dwivedi, can we go to Article 370 because we would like to dovetail this speech with
No,
370.
extremely obliged. Kindly have Lord 371.
371, yes.
A. First, the heading is temporary provision. Under the heading temporary provision,
Which are the features of 370 which according to you would indicate that it would cease to exist after the constitution of J&K has been framed? Which are those? You can just identify
if
them.
we read the debates and dovetail it over here, it will be better.
Yes.
Note 238, note the provisions of 238 shall not apply in relation to the state of Jammu and Kashmir. This provision has ceased to exist in the Constitution of India from 1957 onwards. But it has not been changed for the reason that there is no power to change it. Clause 3 requires Constituent Assembly, Clause 2 requires Constituent Assembly. And therefore, what my friend was right, Dr. Dhawan, when he said 52 onwards, Clause 3 has not been used. 238 is an amendment to Article 370, Lord. Therefore, Clause 3 was the only provision available. And it has not been used, and it is allowed to exist because there is no way you can change it.
Because for 370, you have to amend 370, you have to fall back on clause 3.
Yeah, they have to. But they can't because the precondition for exercise of power is there. Now, Lord, kindly have Lord B, 1B1. That is a one-time power, Lord. There's no dispute about that. Once you determine which are the entries relating to instrument of accession, power ceases to operate. But yet it continues. No one has deleted that. Again, the same logic. Then comes 1B2. Such other matters in the said list, with the concurrence of the government of India, not government of Jammu and Kashmir. Now, reading the statement of Dr. Iyengar, which I placed for much. This is an interim arrangement because at that point of time, there was no other authority to consult or concur. Until the Constituent Assembly comes into being. And that is why 2 comes in. Lord, even I'll go to the extent of saying, Lordship would see logically clause C also ceases to operate. Article 1, it says the provisions of Article 1 of this constitution shall apply in relation to the state. Reason being, Lord, 370, Lord, when the constitution comes, it itself says we are inalienable part of India. And for the federation purpose, Article 1 was there. So we can read both the statements together. There is really no need to go fall back on C. Lordship has seen, Section 3 of J&K Constitution, including the preamble, loudly pronounces them. They are inalienable. And this provision, Section 3 cannot be modified under 147, Section 147, which is the mandatory power of the Constituent Assembly. It's a basic feature of that Constitution, therefore, which is not prone to amendment. That position is settled. Now comes note D. Such of the other provisions of this constitution shall apply in relation to that state, subject to such exceptions and modifications as the president may by order specify. Now this, Lord, immediately refers to the second proviso. First proviso I have already shown is the same thing as 1B1, where the word consultation and concurrence itself is embedded in the provision. So it's more or less reiteration of that. Second proviso says, no such order which relates to matters other than those referred to in the last preceding proviso shall be issued except with the concurrence of the government. And Lordship has seen, the very initial part of the concurrence and consultation was brought in only because there was no other authority. And therefore they said until the Constituent Assembly comes into being. So therefore, in my opinion, humble opinion, subject to what Lordship decide eventually, even 1D becomes ocious. That power cannot be exercised because the concurrence now has to be by the Constituent Assembly. It cannot be, and that is what T2 says. If the concurrence of the government of the state referred to in paragraph 2 of subclause B of clause 1 or in the second proviso to subclause D of that clause be given before the Constituent Assembly for the purposes of framing of the Constitution of the state is convened, it shall be placed before such assembly for such decision as we take. Therefore, even the concurrences and the consultations that have resulted into something, the finality of decision is vested in the Constituent Assembly. It can overturn that concurrence. And that is what the framers say in respect to clause 2, that the finality for determining the status of union and the state relations, as well as the jurisdiction of parliament, rests in the Constituent Assembly. Who will finally determine these things? Well, Constituent Assembly would finally determine through the shape of Constitution of Jammu Kashmir. It can't finally determine otherwise. Final determination has to be the enactment of Constitution, which was done. That is why I wanted to place the other paragraphs now, where they have said this in so many words. The final determination would be that of Constituent Assembly in respect of parliamentary jurisdiction over the state and the union's relations with the state.
Clause 2 does not give finality to the decision of the...
I'm not saying, as I said, please juxtapose the provision with the debate. And the debate says that.
So in other words, we'll be reading an ingredient of finality from the Constituent Assembly debate.
But I'll ask myself.
How can that be?
If the debate says that's the commitment, because Jammu and Kashmir Constituent Assembly will determine the constitution. What is the use of the commitment not made, and what is the use of the constitution when it cannot finally lay down anything? Just look at it this way, Lord. Unless we see 370 in the light of the commitment made, and the commitment was to framing of the constitution. But
Can we say that a speech or an address made by an individual member of the Constituent Assembly, however weighty, represents a commitment by the nation or the Dominion of India to the state of Jammu and Kashmir? This would have a bearing on the interpretation of the constitutional
my answer
provision.
to this is not when we try to see.
But for us to raise it to the point where it's a binding commitment, a speech by a very distinguished member of the Constituent Assembly represents a binding commitment of a nation.
But that statement is not by any member. That was a statement on behalf of the person who answers all the queries on the amendments made. That's a difference.
So very what you're asking us to read into it is something which is not there in the article. But if the article was that this article will get frozen in point of time after the Constituent Assembly of JNK frames the constitution, that doesn't appear to be following. Because that's why I said come to page 427, and that makes it very clear. Because you are reading, we can't read a portion of the debate without going through the entire
Lordship
what
is
has
reading
been
the
said.
last paragraph and I'll explain.
Not the last, yes, the last claim, the last clause.
The
Just read
effect of
that.
this article.
Yes, just read that. You can't read,
effect-
because you can't read portions, dehouse the other, because when this debate is going on,
Fine.
there can be statements and then the explanation to those statements.
Now, Lord, may I answer it in this way?
And the other part is, you see, once you become a part of the nation, become part of it's the entire nation then you are part of.
This is what is creating a problem, Lord. Are perhaps thinking in the manner which we have been tuned to think for last 70 years, Lord, is that one nation, one constitution. But where is that prescribed, Lord? I ask myself. Accepting it could be prescribed in the Constitution of India, but Constitution does not say so.
Anyway, just read that paragraph.
And the effect of this article is that Jammu and Kashmir state, which is now part of India, will continue to be part of India.
No, the one before that. The last clause refers to what
Right.
may happen later on.
The last clause refers to what may happen later on. We have said Article 211A will not apply to Jammu and Kashmir. This is Article 238. But that cannot be a permanent feature of the constitution of the state, and hope it will not be. So the provision is made that when the Constituent Assembly of the state has met and taken its decision, both on the constitution of the state and on the range of federal jurisdiction over state. Can you notice that? State, the president may, on recommendation of the Constituent Assembly, issue an order that the Article 306A shall either cease to be operative or shall be operative only subject to such exceptions and modifications as may be specified by him. Now, Lord, I ask myself this question.
Just read further in the last paragraph there.
But before he issues any order of this kind, the recommendation of the Constituent Assembly will be a condition precedent.
Correct. Now read the next paragraph also.
Well, the effect of this article is that the Jammu and Kashmir state, which is now part of India, will continue to be part of India, will be a unit of the future Federal Republic of India, and the Union Legislature will get jurisdiction to enact laws on matters specified either in the instrument of accession or by later additions with the concurrence of the government of the state, and steps have to be taken for the purposes of convening the constitution. Lordship may not detach one line before the succeeding line. It says concurrence of the government, and then effort should be made to establish the Constitution of India. So this is what, I mean, the Jammu and Kashmir, the Constituent Assembly. Now, Lord, if your Lordship would read it with the first part and this part, Lord, after all, this they are elaborating. So we can't detach the first part from the last part. So we are not, with due respect, Lord, we cannot snatch away this part, Lord. Steps have to be taken for the purposes of convening the Constituent Assembly in due course, which will go into matters I have already referred to In other words, Lord, all this is talking again of that interim period. The concurrence, and otherwise, not the first part says concurrence ceases till the constitution comes into, constituent assembly comes into being. And if we read later part as saying that no, it will still continue, that there's a contradiction to that. Lord. And therefore, not my cohesive reading shows that perhaps when they gave this this power of consultation and concurrence to the government, it was in a peculiar situation, not beyond that. And that is the key. As I said, that was the key to indicate what was the scope of 1B1 and 1B2, including 1D, the two provisos. And it's nobody's case, 2 and clause 3 survive beyond 1970, 57.
After the Constituent Assembly took its decision on 26th of January 1957, the Dominion of India would have no power to apply any other provisions of the Constitution to Jammu and Kashmir.
They have all the powers. As I said, if Lordship would see the 44th Amendment, which is the basis for Constitution of Jammu and Kashmir. That gives Union of India all the entries which it has under the Constitution of India, 1 to 96. Excepting 97 is not there because residuary power is there with the state. Section 5. That was not, I'm not here to judge whether they were right or wrong. I'm here only indicating to your lordships that this is one of the intents clearly falling from the interpretation which they had given to 370 only. And we have always argued, we have always said, look into the debates to cull out the intent of the provision. So all that I'm saying is kindly look into the debates to cull out the intent of 370. And when we see the debates along with 370, it clearly emerges that his power is not available thereafter. And that is where I submit with respect, Lord Sampath Kumar is wrong. Lordship, I have indicated in my written, Sampath Prakash. And the biggest mistake committed by Sampath Prakash, if Lordship would see, is they relied upon 1952 presidential order, which incorporates, that's the explanation. If Lordship would see 370 explanation, that was what was incorporated by Sampath Prakash, modified. Initially, it was the dynastic rule that the president will recognize the Raja as Sadr-e-Riyasat. But 52, the Constituent Assembly moved a motion and abolished this dynastic rule and said now Sadr-e-Riyasat would be elected by the Assembly or on the advice of the government of Jammu and Kashmir. Now, this was sent to the government of India with the concurrence of the Constituent Assembly under clause 370. And it was incorporated in the form of an explanation to 1 that Sadr-e-Riyasat would be. Now, the Sampath Prakash assumes that this 52 order, continues the Sadr-e-Riyasat, and therefore it shows that they wanted permanence to 370. But they erred in one respect, and something which was not pointed out to them. Kindly have section 27 of the Jammu and Kashmir Act.
So, Dwivedi, your submission is that defunct provisions of the Constitution, 370 was a defunct provision of the Constitution. No purpose in having it there, yet it continues to be there. Everything would be determined by J&K Constitution.
I'll answer that.
COs have been issued from time to time, pre-57 and post-57.
I'll answer.
And yet, nobody thought about it. Yet the so-called affiliation with 370, a section of the people feel was also negatory, because nothing survived.
Lord, may I please permit me to answer this,
Difficult to go
which
that
has
far.
fallen from your lordships, not that the past practice is going to justify the invalidity of that.
Past practice.
That's not the law. Laws, as I understand, is howsoever long the past practice may be, if it is constitutionally illegal, then it cannot be justified. And I'll show, Lord, here kindly have section 27 of the Jammu and Kashmir Constitution. It is volume 20. Not howsoever much we may not like it, no, we may not approve it, but the fact remains, all that I'm trying to show is the intent. And should we read Article 370 was the intent? No, that's my question.
We read an intent based on the constitutional law debates according.
But
How
that's how we infer the intent.
how it transpired after that, how it has worked out is, you say, irrelevant
That's
completely.
why I said, not any amount of illegality or action that may have been taken subsequently cannot justify the invalidity. Once it is, I'll show.
Yes, what do you
But
want?
questions can never be not the.
Which volume do you want us to see now?
Yes. Kindly have not volume 20,
Page? What page would that be?
PDF page 310.
Page?
310.
PDF page not 310. But I know, Lord, I'm advocating a cause which may not sound very. I mean, in fact, which may not sound.
No, it's not that, it's not that, please.
I was conscious of it.
I know. You see, the explanation which was added in 1952 refers to the Council of Ministers.
I'll answer that.
It refers to the,
27.
but it doesn't refer to the Constituent Assembly.
It does.
And it doesn't refer to the Constituent Assembly.
It does.
Explanation. And it defines the expression government of the state for the purpose of that article.
Yes.
It defines the expression government of the state for the purpose of that article.
And that is with the concurrence of
And
constituents.
there lies the distinction between the Constituent Assembly debates, because
Kindly let me
Constituent
complete.
Assembly debates are not relevant as far as the explanation is concerned.
That's not correct. That's what I'm saying. Kindly have section 27.
What
Lord,
I'm
this
finding-
Sadr Riyasat in that form continued under Constitution of Jammu and Kashmir.
One thing I'm finding difficult to accept, you
Ma'am,
persuade is that.
I know, Lord, it is difficult.
No, I'm saying so that the Constituent Assembly debates amounted to an assurance that 306A or 370 would dissolve itself.
I'm not saying that.
And whether after that it did or not, it has dissolved itself.
No, that's not right way of putting my question, not my answer.
If you say 370,
No, I'll
the
answer that.
statute dissolves, it's
No, what
automatically.
I'm saying is, Lord, debates indicate the intention behind 370 and the scope of 370. Because it's very common, Lord, every time when we see this, Lord, want to investigate and go into the question of intention of the framers.
I thought you said 370 doesn't exist. According to you, it's
Yes,
only
yes.
on paper. It doesn't.
Post 97, post 57.
Yes, yes. So I am saying what you say is the constitution debate should be read in a manner that 370 was intended to dissolve itself on the Constituent Assembly completing the JNK Constituent Assembly completing the process.
No,
And it has inadvertently remained on the statute, over which some people
that-
seem to
that-
be very,
Not
let me say better words, feel very strongly about 370.
fair deploy, my lordships. Lord,
Oh,
just say lordships would have
I
their
am putting
lordships
to you the
opinions, Lord, I can't
consequence. I
say.
am putting to you the consequence, what would happen
No,
were we to accept what you are saying.
But
This is what
what
I'm
will be
only
the
trying to
consequence?
put it
Lord,
in
I ask
perspective.
myself, Lord, I don't feel that there would be any adverse consequence, Lord. Once we accept, please keep this in mind for a moment, Lord, that yes, two constitutions could have separately existed cohesively, Lord. But what will be the consequence, I ask myself, Lord? And that was the intent of the framers, and they felt, Lord, eventually Kashmiris may agree to something which is like other states, but then they didn't enforce that. They still permitted constitution to be framed. But constitutions are not made for a day, lordships have held in 2018. They are made till the lifetime of the state or the nation. They're not made for a day or two. They can't be held to be an interim measure, to be chipped off and on. Now, please have 27. Lord, what the Supreme Court in Sampath Kumar overlooked was that explanation did not continue. What continued thereafter was 27 section.
Really, the net consequence would be that the Constitution of India, in its application to the state of Jammu and Kashmir, would stand frozen as of January 1957. Therefore, no further development in Indian constitutional law can at all apply, according to you, to the JNK,
Exactly.
to the state of Jammu
Both
and
that
Kashmir
state, because-
after 1957.
Because Constitution of Jammu and Kashmir
How
itself.
can that be acceptable?
We may ask this question how, but the question is which provision of the Constitution permits that except 370? Now, if I am right in my submission, the 370 ceases to operate. then which other provision would
But
take
if Article 370 ceases to operate and Article 1 continues to operate, and then Jammu and Kashmir is an integral part of India, surely the jurisdiction of every democratically elected institution in India is not excluded in its application.
What I'm saying here again, not let me reiterate.
There has to be then a provision in the Indian Constitution which excludes its application to Jammu and Kashmir, and there is none then according to your argument.
This may be our wish. But the point is, let us look at the provisions of the Constitution. This is what I'm saying.
So the very, in fact,
70.
in fact, your argument now cuts across the other side argument.
That's right, no? They
Your
are
side argument itself. You're cutting, you're cutting at,
No, but
you see, and,
there's a difference.
and just look at the second proviso. Just turn to the second proviso.
Yes.
Except with the concurrence of that government. Now, the government has been defined, and the argument of your side, some of your colleagues on your side, is government, and the government of the day, council ministers, is different from the Constituent Assembly and the Legislative Assembly.
No, this is where
And here, the second proviso does not use the expression Constituent Assembly. It says except with the concurrence of that government. And government has been defined by pursuant to the amendment in 1982. And therefore, your challenge or to the dictum in Sampath Kumar is slightly, gets into difficulty. Because that's the intent behind it.
May I answer that? No? When it says that government, what it means is the government which was preceding the Constituent Assembly.
That's
It can't
contrary to
be
the
any other
explanation.
government because then two falls.
That's contrary to the explanation.
I'll answer. But kindly bear with me. Why do I say so? After second proviso, there is clause 2. And what does clause 2 say? Whatever concurrence has been given prior to Constituent Assembly has to be placed before Constituent Assembly for enabling it to take a final decision.
What it means is this, that if there is concurrence, because initially when the Article 370 was there, it was Sadr Riyasat and the other council. After that, at that time, if any decision is taken, it will be with that.
Sadr Riyasat continued.
I know, I'm aware, but the explanation which is added is with regard to then the Council of Ministers. The explanation in 1952, which was added by the concurrence of the Constituent Assembly, was with regard to the Council of Ministers.
So there's no difficulty, Lord. We are reading little, with due respect, Lord, we are reading little too much on that. Because have section 27 to 32. It is the Sadr Riyasat elected by the Legislative Assembly who will be the Sadr Riyasat. And obviously the recommendation goes through the Council of Ministers, not otherwise. So the Council of Ministers and Sadr Riyasat as well as Legislative Assembly are all there, elected. And then not by explanation, relying on the explanation to 1952 order, he cannot say in 57, Lord, Constitution does not seize 370. Lord, that doesn't follow because Constitution includes Sadr Riyasat. The continuance of Sadr Riyasat had to be as per section 27, it couldn't be, and that was the fact. So this assertion in Sampath Kumar, relying upon the 52 presidential order, adding the explanation of elected Sadr Riyasat is not correct. Lord, there are lots of misconceptions. For instance, Lord, in Damanu's case, which I think one of my friends may have cited that. Lord, please read clause 2 in the debates, Lord. Please read clause 2 in the debates, Lord. Lord, may I pay here? Lots of clarification would be there if your Lordship would read the explanation to clause 2 in the debates, Lord. Page 427, the same page. Page 82. Then we come to clause 2. The passage is not paragraph. Then we come to clause 2. You will remember that several of these clauses provide for concurrence of the government of Jammu and Kashmir and the Jammu and Kashmir state. Now these relate particularly to matters which are not mentioned in the instrument of accession, and it is one of our commitment to the people of people and the government of Kashmir that no such addition should be made except with the consent of the Constituent Assembly, which may be called in the state for framing of the Constitution. In other words, what we are committed to is that these additions are matters for the determination of the Constituent Assembly. That explains Lordship's question. It may be 1, 2, second explanation, but it comes before clause 2. After reading the explanation in the clause 1D, they come to clause 2. Not otherwise, not the whole reasonable not the sequence denoted in the Article 370 has no meaning then. And this note paragraph includes this. And then also the next paragraph is equally so far as the other thing is yes. Just one paragraph. No? Now you will recall that in some of that has been done. That we have read. We have read. Now, Lord, as I said, Sampath Kumar was not, Prakash was not rightly decided. And if your Lordship would just have a look at Sampath Prakash, Lord, that perhaps may eventually conclude my argument. Sampath Prakash is?
Which is the provision of the J&K Constitution equivalent to Article 245 or 246?
They have their own Section 5, which defines the powers of both state and indirectly the Parliament. Section 5 will not have. And this is what continued for a long period of time. If practice is relevant, then this is continued for a long period of time till this order comes. Can we have Section 5? That is for lots of convenience, but volume 2, PDF page. I may first refer to the preamble.
Now see the problem with your argument, because Article 5 says that the legislative and executive power of the state would extend to all matters except those with respect to which Parliament has power to make laws for the state.
Yes.
Under the provisions of the Constitution of India.
Yes.
Therefore, that takes us to the Constitution of India.
No, the reason being
that therefore postulates that the Constitution of India does apply to the state of Jammu and Kashmir.
That overlooks one important factor. And that is the 44th Amendment immediately preceded with the concurrence of Constituent Assembly, where they had elaborately defined what are the provisions of the Constitution of India would be applicable to Jammu and Kashmir. And this Constitution is elaborately based on that 44 order. And therefore, it presumes whatever power has been given to the Parliament under the scheme of things, 44, there what they have indicated is entries 1 to 96 of list 1.
But unless for the purpose of the argument of this side, unless we accept that Article 370 did continue until 2019, there would be absolutely no trammel on the jurisdiction of Parliament under Section 5.
Not, as I said, not
because 5 says except those with respect to which Parliament has power to make laws for the state under the provisions of the Constitution.
But there's not
now, under the Constitution, but for 370,
yes.
Parliament would have the power to make laws with respect to all aspects in List 1 and List 3. Now, if your argument is that 370 goes,
the moment we come to
then
this,
where is the limit on the power of Parliament?
I'll answer. It has, Parliament has power to make laws. Now let us fall back to that stage. What was the power given to Parliament at that point of time to make laws? The 44th presidential order, 48th presidential order, which is 1954. It elaborately determines what is the scope of parliamentary jurisdiction, that is entry 1 to 96. Now, if we add entry 97 to that, again, because that is Parliament's power. Then what will be the fate of Section 5?
But then you've been arguing all this while that these constitutional orders are a matter of constitutional practice. They're contrary to the provisions of they're contrary to the constitutional provision. If we accept your argument and therefore don't look at the constitutional orders, then this is the consequence which follows as a sequitur of your argument, that there would be no restraint on the power of Parliament then.
The sequitur is this, Lord, that after the 1954 order, there couldn't have been any other order. And that is why they say in respect to which Parliament has power to make law. Otherwise, again, I fall back on the same theory. Internal sovereignty continued with the state. The constitution ensures that internal sovereignty, there is the whole legislative provision, the executive provision, and the judicial provision. What is the utility of that, Lord, if 370 continues to infiltrate? As I said, add entry 97, that is the residuary power. Then what remains of this? And yet the commitment was there. All that I am suggesting time and again is, see it in the light of the object of 370, the intent. The object of 370 was only to ensure that no one from outside interferes with the constitution making. That was the object of 370 as the framers have delineated. So therefore, otherwise, Lordship may see 254 doesn't apply.
Dwivedi, now I think we've really understood your perspective. Can we now wrap up?
Yes. So Sampath Kumar, I've already indicated.
You've already argued Sampath Kumar, so we'll now.
Prakash,
there's some people who have to follow now.
It is wrong.
Thank you so much, Mr. Dwivedi. Thank you very much.
There's one aspect. There is one aspect which I want to throw light on, which fell from Justice Paul. But since there has been repeated exercise of power since 1957 onwards, under 370, therefore that speaks of the validity too. We have to take that into consideration, if I have understood rightly. It can't be that the power was not there yet it was being exercised. Now, there are two authorities which I cite here. And one is which we could call out, because the argument fell from your lordship's note. Your lordship would permit me, what CJI has to say on that?
What is the proposition you are seeking to
The
make?
proposition is that howsoever long the practice may have been, acquiescence, howsoever long it may have been, that will never confer validity on the provision if the power is not there.
That may be, what has been put is not in that fashion. What has been said is if there are two interpretations which are possible.
No, not that. I'm not.
That's what was put to you.
What is being put is the way it has been understood by everyone.
No, as I said, if two interpretations,
Now, at this stage, you say, no, all that has happened over the last so many decades
That's
is
what
wrong.
Lordship
Nobody
did.
understood the constitution of JNK, nobody understood the constitution.
That's what
of
lordships did in Lord Golaknath.
said.
That's what your lordships did in Indira Sahni. Not in Indira Sahni. No, please recall what happened in Indira Sahni.
All right, we've taken the point that
Yeah,
the
understand.
constitutional practice will not legitimize a constitutional.
That will not legitimize.
Fair enough. Thank you, Mr. Dwivedi. Thank you very much. We'll now go on to the next, Mr. Singh. Yes, Mr. Siv Singh now.
But there is one decision that we'll just make a note of it.
Yes.
1961, Supreme Court. AIR 1961, Supreme Court, 964. Para 1 and 2.
964.
What is the name of the case?
This is Amalgamated Coalfields Limited. So just two paragraphs. No?
All right.
1 and 2. It's a constitution bench. Again, they said these are questions cannot convey any kind
Thank
of
you, Thank you, Mr. Dwivedi. Yes, Mr. Singh.
And all that I'm saying, Lord, if two views are possible, let's take the view in favor of the Constitution of Jammu and Kashmir. The autonomy which we had promised, the commitments made.
Thank you, Mr. Yes, Mr. Singh. Thank you, Mr. Dwivedi. Yes.
I'm obliged. But I hope I have not ruffled too many
No,
feathers.
not at all. It's an intellectual exercise, Mr. It's a debate. I mean,
The debate, therefore, we will give our perspective of what we perceive where the debate may be going, so that you have a chance to, clarify to us. That's all. Otherwise, as I always say, simplest thing is to keep silent. But that's not good for the lawyers.
Questions are put to get an answer. It's not the conclusion. Questions are never the
I have been
conclusion.
faithful to that.
thank you, Mr. Dwivedi. Yes, Mr. Singh.
Just take your iPad.
I must say it's been one of the highest intellectual debate that we have seen for a long time. But we are all grateful to your notice for
Thank you, Mr.
taking it to that level.
Thank you, Mr. Dwivedi.
Nobody has misunderstood your notice.
Thank you, Mr. Dwivedi.
Please be rest assured. It's been a privilege for us.
Thank you, Mr. Dwivedi. Likewise for us also, it's a
We've got some
Share,
excellent assistance and various nuances of the constitution from all of you.
it's really, the bar has taken the jurisprudential analysis to a different level. And I'm sure we'll be hearing more of it from the other side now after we conclude today. Let's see. Thank you very much. Yes, Mr. Singh.
I took your lordship's the suggestion which fell from the court at the case management hearing which took place on 3rd July. I took that very seriously. I consulted my colleagues, and I am concentrating only on the State Reorganization Act because Article 370. I'm adopting the argument. My written submission also I've noted. I've adopted the arguments of Mr. Raju Ramachandran because they were available at that time, and of Mr. Gopal Shankar Narayan, the written submissions on 370 and the abrogation and all those aspects.
Now, Mr. Singh, can you just formulate
State
what your submissions on the Reorganization Act are going
I'll-
to be? If you can just, we'll take it
I'll tell
down.
your lordship, they are broadly in my written submission, but there are some nuances and finer points which I have to, which I'll place before your lordship. Broadly, it is this, Mullah. First of all, the proclamation, the presidential proclamation of 19th of December 2018, paragraph C2, Roman 2, is void. And that is the one by which the two provisos to Article 3 was suspended. The two provisos which applied to Jammu and Kashmir in Article 3 was suspended without even concomitantly applying the proviso which exists for the rest of India. That's number one. I'm just formulating the proposition.
Just one second.
That being void, on the 5th of August and 6th of August 2019, it is my submission that the two provisos applicable to Jammu and Kashmir were very much have to be treated as being in force. Two is that I'll hand across a one-page timeline. The timeline of how the resolutions and amendments were executed on the 5th and 6th of August 2019 shows, Millards, that there is absolute legislative legerdemain, something which is, it boggles the imagination. I'll show your lordship that neither the Constitution of India nor the Constitution of Jammu and Kashmir are applied, and what is done is just by a sort of sleight of hand. It'll become. I don't want to.
How would you formulate the second point?
The-
The first we got, that the
point,
proclamation.
I'll just place that before your lordship. But what I'm
Sort
saying
of
basically
formulate
is
it, conceptualize it so we can just. then-
the point is, Millards, that the CO 273, which comes to be issued on 6th August, is in a sense applied in anticipation. A bill is presented by. I'm only on the Reorganization Act now. The bill for reorganization is presented by the President, tabled in the Rajya Sabha, passed by Rajya Sabha on the 5th of August, then tabled in Lok Sabha on 6th of August, and simultaneously with the recommendation of Lok Sabha to the President to issue CO 273, but simultaneously, even before 273 has been issued, Lok Sabha passes a bill which is purportedly passed by the Rajya Sabha the previous day. I'll just make good the proposition. I'm just outlining it.
So,
So what happens
you
ultimately?
just said, what is the proposition? That they dove-tailored and managed the time in a manner, everything occurred within this 2 days' time. But we wanted to know, what is that you're selling? What is the
The
time?
point is that the provisos which are in place and the explanations, the two explanations, which are in Article 3, the two explanations were not applicable in Jammu and Kashmir because the 18th Amendment was never extended to Jammu and Kashmir. So the explanation which said that it's a union territory, the argument is that we can interchange states and union territories under Article 3 because of the two explanations which were introduced by the 18th Amendment. That was not applicable to Jammu and Kashmir on the 5th of August. So as far as Jammu and Kashmir is concerned on the 5th of August, it was only a state. It could, any changes under Article 3 could only be state to state. But I'll come to it. I'm just formulating the points. I'll hand across this. Now, dehouse this aspect. My submission is that Part 1, that is Articles 1, 2, 3, and 4, have to be read conjointly. And when you read them conjointly, no power can be found in Article 3 to convert a state into a union territory, notwithstanding the two explanations which are added by the 18th Amendment. Four,
One second. Yeah,
4 or 5, because I might lose track because it's all oral,
it's 4.
is that if two interpretations were possible as far as Article 3 is concerned, then that reading should be preferred, which would be in keeping with the principles of federalism, the principles of democracy, the principles of the representation of the people of a state, and which would keep Article 3 out of conflict with Article 368. That reading should be preferred, and not a reading where Article 3 is allowed to ride roughshod, coach and horses through Article 368 without any of the safeguards introduced in 368. And this, Lord, I'll show your lordships, not just from the constitutional reading, but from the history of the article, Article 3 and Article 363, 4, that is 1 to 4, but 3, 4, and Article 368, and the view taken by your lordships in certain judgments, as well as Dr. Ambedkar's speech on Article 304, which was 368. That there has to be a harmonious construction between these articles, where that article 3 and 4, which allow an amendment to the constitution, but by a simple majority in parliament, can't impinge on those amendments which have the effect of either which attract the proviso to 368 or which in any case require a special majority by their very nature.
Will you be referring
So
to the
history of
text to the constitution for developing an argument? How
Yes.
should we now go about it? We made your 4 points. We made a note of the 4 points.
No, there is a little more here. So these are the broad issues. There might be some finer points. So let me just start straight away with, and I'm going to try to be brief, but I just want to preface it by saying that since I had confined myself to this subject, several of Mr. Kapil Sibal, Dr. Dhawan, etc., all touched on Article 3, but they made it clear that they're leaving it to me to argue this.
So let's see Article 3 first.
So I'll ask for some latitude from your lordship on time because of this. And I believe that the Reorganization Act, apart from 370, is very, very important for the people of Jammu and Kashmir. And also that if this interpretation of Article 3 were to be upheld by your lordships, then this is the thin end of the wedge for democracy and federalism in the country as a whole. Because any party in power at the center if it also happens to be the party in power in a given state, can just convert that state by a simple majority in the state legislature and a simple majority in parliament can convert the state into a union territory. This is a proposition of a course
All
of
right, let's
action.
see Article 3 now.
Which is fraud. I'll come back to Article 3 in a moment. First, I'll go see,
Yes,
in the same
certainly.
sequence. So first, para C2 of the presidential proclamation.
Where did you get that?
In volume 3, page 92 of the document, volume 3 of the documents. Page 92. This is expressly under challenge in at least 4 of the petitions. And Mr. Raju Ramchandran's written submissions open with this also. So if we come to C straight away, now therefore I hereby proclaim, I make the following incidental and consequential provisions which appear to me to be necessary or desirable for giving effect to the objects of this proclamation, namely, I'll come straight to 2, the operation of the following provisions of the Constitution and of the state constitution is hereby suspended, namely, so much of the first proviso to Article 3 of the Constitution as relates to the reference by the President to the legislature of the state and the second proviso to that article. And then so much of clause 2 of Article 151, etc. But I'm concerned with this part in particular. So much of the first proviso to Article 3 of the Constitution as relates to the reference by the President to the legislature of the state and the second proviso to that article. This is now referring to the Constitution as extended to Jammu and Kashmir, because there are 2 provisos in Article 3 which were introduced by the 1954 presidential order.
Just one thing, Mr. C. Singh, the word used over here is suspended.
I'm sorry?
The word used over here is suspended.
Suspended, that's right.
It's not.
No, suspended. Now, we are talking about a presidential proclamation where the Constitution has not been able to be worked on the report that the President has presumably got from the governor, etc. And therefore, there's a presidential proclamation under 356.
No, I specifically drew your attention to this because you said that if we, while referring to the 4th argument of yours, the 4th contention of yours, you use the phrase that in case this is, there is possibility of misuse.
By suspending and then changing the nature of the state.
Please continue with the argument.
The suspension becomes like an obliteration. If you suspend a requirement to consult the people of the state and then change that state into a union territory, that suspension it's an obliteration virtually. It doesn't. It might not make any difference whether we call it a suspension or obliteration.
Singh, are you approaching it from the perspective of Article 356, that the power under Article 356 cannot be used to achieve these ends, such as the suspension? I mean, how are you further exploring the point?
Yes, unless this was in furtherance of the object of 356 and it pertained to a body or authority of the state. Here, the suspension is of a constitutional provision which deals with consultation with the representative body of the state, which is the legislature of the state, the legislative assembly of the state. Now, this can't have any even the remotest nexus with an Article 356 object to suspend consultation with the legislature of a state, or even, I'm now arguing against myself, or even the substitute for that legislature, which is Parliament, to suspend that consultation altogether, can't have any nexus with the object of 356. 356 is for the purpose of, because the constitution hasn't been working in that state, or the state isn't able to be governed as per the constitution, and therefore there's a temporary suspension. And your Lord, I don't want to go into repeat arguments on 357.
The argument on your side has been that 356 is for the purpose of restoring democracy, not for abrogating. That was the argument.
That's right. And this, unless the union were to tell your lordship when they start their arguments, whenever they do, unless the union is to tell your lordship that yes, it was an object of Article 356 to change Jammu and Kashmir from a state to a union territory, they can never justify this as having any nexus with the object of 356.
Therefore, there are two distinct arguments. Therefore, one, whether the power under Article 3 can at all be utilized to convert a state into a union territory. That's one.
That I'll come to subsequently.
And the second, whether this power was correctly utilized or constitutionally exercised at a time when Article 356 was in operation. Does Article 356 empower the union to do this?
That's right. But
there are two different areas which we would like to hear from you very briefly.
I'm very grateful to my Lord the Chief Justice, but this is one step before that. I'm saying that if you read, it says, make such incidental and consequential provisions as appear to the President to be necessary or desirable for giving effect to the objects of the proclamation, including provisions for suspending in whole or in part the operations of any provisions of this constitution relating to any body or authority of the state. So my argument here is, one, such the para C2 can never even remotely be for giving effect to the objects of the proclamation. On 18th of December or 19th of December 2018, the object of the proclamation was not for changing the status of Jammu and Kashmir. And if it were, then it's a fraud on the Constitution. It's an absolute fraud on the Constitution if you admit that this had a nexus with your object on 18th of December.
In fact, to stretch your argument could be that the object of any proclamation under Article 356 can only be to ensure that the government of the state is carried on in accordance with the provisions of the Constitution.
As a stepping stone to restore full democracy in that state. I bow to your Lordship. I couldn't have put that better, very neatly. And I am very happy to adopt that line as my own. Now, in this behalf, if your Lordship will state away, I'll rather than take your Lordships into Bomai, in my Lord's, the Honorable Chief Justice's judgment in opinion in Krishna Kumar Singh, if my Lords are kind enough just to see that what is the judicial scrutiny required on a proclamation, presidential proclamation, volume 21 of the case law compilation.
Page?
At PDF 61, PDF 60, I'm sorry, because your Lordships have...
Which volume, Mr. C?
Volume 21, PDF 60, paras 55 and 56. Your Lordships have set out...
this is 7 judges, right?
Yeah, my Lord's judgment was 7 judges, and your Lordships have just extracted a very apposite portion from Bomai.
Page 60. Page 60.
Which page?
PDF 60 in volume 21 of the case law compilation. Your Lordships have it?
This one.
Look at the foot of that page, Placetum G, just one line above Placetum G, elucidating the approach of the court when a proclamation under 356 is questioned. Justice Jeevan Reddy held in Bomai case, para 373, whenever a proclamation under 356 is questioned, the court will no doubt start with the presumption that it was validly issued. But it will not and it should not hesitate to interfere if the invalidity or unconstitutionality of the proclamation is clearly made out. Refusal to interfere in such a case would amount to abdication of the duty cast upon the court, Supreme Court and High Court by the Constitution. The standard of judicial review was formulated in the following observations, Bomai case, para 374, and the truth or correctness of materials cannot be questioned by the court, nor will it go into the adequacy of the material. It will also not substitute its opinion for that of the President. Even if some of the material on which the action is taken is found to be irrelevant, the court would still not interfere so long as there is some relevant material sustaining the action. The ground of mala fides takes in inter alia situations where the proclamation is found to be a clear case of abuse of power or what is sometimes called fraud on power, cases where this power is invoked for achieving oblique ends. I'm confining myself to C2. I'm not, others before me have argued on the larger issue, but since I'm on the State Reorganization Act alone, I'm just keeping it as narrow as possible. C2, I submit, is clearly beyond the purview of the 356, and except for revealing the underlying intention of that proclamation, it does nothing more. C2. Nonetheless, in Rameshwar Prasad, a constitutional Chief Justice Sabarwal, then speaking for the bench in Rameshwar Prasad, at volume 3, PDF 96, if my lords are kind enough to come to that. Actually, PDF 95.
Mr. Singh, is the conversion of the state into a union territory, is it severable from the abrogation of 370 itself?
Yes, yes. It is. The two are completely separate. Here, what has happened is that are relying on Article 3. They have by passing a simple law, simple parliamentary law under Article 3, a State Reorganization Act was passed. And
so your argument on the conversion of J&K into the two UTs, that would really survive irrespective of the decision on the abrogation of 370.
Submission starts with that this is completely independent of the abrogation. Whether J&K was from day one completely under the Constitution of India with no commas and full stops taken out of it, whether it was under 370 as applied to J&K, with any permutation
even
and
if you were
combination.
to exercise this power according to you in relation to any Indian state,
that's right.
This would be unconstitutional.
That's right.
Irrespective of the special considerations which apply to J&K in relation to 370.
Yes, yes. And irrespective of the proviso also, the scheme of Part 1 and read with Article 368, and I'll show you, Lordship, it completely precludes such an exercise. Also, when I come to the history, your Lordship will find that all right from the 1919 Government of India Act, 1935 Government of India Act, the precursors to Articles 3, 4 and 368, and then the Constituent Assembly debates, and then what came about, this was never the powers given to the Crown, initially to the Governor General in 1919, to the Crown in 1935, and to the Parliament in 1950, were powers meant to mediate when a minority, perhaps in a state, made out a justifiable case for greater self-representation. Suppose there's a linguistic minority in a state, but they have a distinct area, like Haryana was in Punjab, or Himachal was with merger of princely states. The idea, or let us say there's certain other reasons where there are people who can't get a majority in that state assembly to accept, but they make out a case for greater autonomy, greater representation, for full statehood. Parliament under Article 3 and 4 acts as a mediator. Because
how were the UTs born in
yes,
the Republic?
I'll come to that.
I think in my judgment in NCT 2, I've dealt with the whole history of how the UTs were created.
You have. But
and were the UTs, in other words, was there a peculiar constitutional history attached to the creation of UTs?
Yes.
And does that category remain frozen now?
In fact, that category has moved consistently towards full statehood. By the 4th of August 2019, there were only
the origin of the creation of UTs.
Yes. But look, may I?
We'll have to then, because that your argument will have to explore in this way. What is the history surrounding the creation of union territories under the Indian Constitution? Yes. 2, does that category then remain a sort of frozen category in the sense that you can convert a UT into a state, but you can't do the reverse process? That's the second point.
And that is historically, that is what has happened. So by 4th of August 2019, there were 7 UTs left in India. And they were Delhi, Chandigarh, Delhi, Chandigarh, Daman and Diu, Dadra and Nagar Haveli, Puducherry, Lakshadweep and Andaman. All other UTs were gradually, once they could become viable units, the moment an area could become a viable unit as a state, it was converted into a state.
What do we find? I mean, how are the UTs created?
Yes. So, look, can I just then give your lordship the pages for this first argument? Just so that...
yes, certainly. And then we can move to the next.
You're
on Rameshwar Prasad until I...
Rameshwar Prasad, look, volume 3, page 95, PDF 95. Para 96. Here, my lord, Justice Agarwal spoke for the bench. It was a unanimous verdict of the Constitution bench.
And what is the principle which Justice Agarwal has laid down there in para 90?
On the nature of the power under 356 and the nature of the scrutiny, he goes a step further beyond Bomai. I'll only take your lordship very pointedly to the short 3 or 4 important paras. 96, Justice Agarwal says the power under Article 356(1) is an emergency power, but it is not an absolute power. Emergency means a situation which is not normal, a situation which calls for urgent remedial action. Article 356 confers a power to be exercised by the President in exceptional circumstances to discharge the obligation cast upon him by Article 355, which Mr. Nafde pointed to. It is a measure to protect and preserve the Constitution. The governor takes the oath prescribed by 159 to preserve, protect, and defend the Constitution and the laws to the best of his ability. The power under 356 is conditional, the condition being the formation of satisfaction of the President as contemplated by 356(1). My submission is that this applies equally to 356(2). And when the President is satisfied that certain measures need to be taken to fulfill the object of the proclamation, that also must meet the same test. Then look, para 97. There's an extract from Bomai in para 97 of the foot of that page. When the proclamation is challenged by making out a prima facie case with regard to its invalidity, the burden would be on the union government to satisfy that there exists material which showed that the government could not be carried on in accordance with the provisions of the Constitution. Since such material would be exclusively within the knowledge of the union government in view of the provisions of 106 of the Evidence Act, the burden of proving the existence of such material would be on the union government. And then, my lords, next para, overleaf, PDF 96, in para 98, just placidum C may be seen. if and when, this is Justice Jeevan Reddy's opinion in Bomai, if and when any action taken by the president in exercise of his functions is questioned in a court of law, it is for the Council of Ministers to justify the same, since the action or order of the president is presumed to have been taken in accordance with Article 74(1). And then 324, para 324, at the foot of that page of Bomai, in our respectful opinion, the above obligation cannot be evaded by seeking refuge under 74(2). The argument that the advice tendered to the president comprises material as well, and therefore calling upon the Union of India to disclose the material would amount to compelling the disclosure of the advice is, if we can say so respectfully, to indulge in sophistry. The material placed before the president by the minister or council of ministers does not thereby become part of advice. Advice is what is based upon the said material. Material is not advice. And I won't trouble your lordships. And then para 100 is very important. Overleaf at page 97. The above approach shows objectivity even in subjectivity. Constitutionalism or constitutional system of government abhors absolutism. It is premised on the rule of law in which subjective satisfaction is substituted by objectivity provided by the provisions of the Constitution itself. This line is clear also from Maru Ram. And look, then if your lordship would just come to PDF 120, PDF 120, paras 138 and 140, they're very short paras. PDF page 120 of the same volume, volume 3, paras 138 and 140. 138, clearly Bomai case expanded the scope of judicial review. True, the observations of Justice Reddy were made in the context of a situation where the incumbent chief minister is alleged to have lost the majority support or the confidence of the House, and not in the context of a situation arisen after a general election in respect whereof no opinion was expressed. But in our view, the principles of the scope of judicial review in such matters cannot be any different. And then para 140, thus it is open to the court in exercise of judicial review to examine the question whether the governor's report is based upon relevant material or not, whether it is made bona fide or not, and whether the facts have been duly verified or not. The absence of these factors resulted in the majority declaring the dissolution of the state legislatures of Karnataka and Nagaland as invalid. And lastly, my lords, Madhav Rao Scindia in volume 6, Volume 6, PDF 457. Para 111, I think, has been shown to your lordships by Mr. Nafde, perhaps. But para 113 at page 457 is very important. Volume 6, PDF 457. Para 113. 113. By express injunction in Article 53(1) of the Constitution, the executive power vested in the President is directed to be exercised in accordance with the Constitution. That power is intended to be exercised in aid of and not to destroy constitutional institutions. Granting that power to recognize a ruler carries with it the power to withdraw the recognition of the ruler. The power must be exercised bona fide and in the larger interest of the people, consistently with the provisions of the Constitution, to maintain the institution of rulership. Power may therefore be exercised in the course of and for recognizing another person as a successor to the ruler, having regard to the laws and customs governing the state. The president is not competent to recognize a person as a ruler who is not by the custom and law qualified to be a ruler. The president cannot obviously withdraw recognition of a ruler and recognize another, nor can he lawfully depart from laws and customs of the state to introduce a person as a ruler who is not by ties of blood, etc., etc. Now, the next page, overleaf, 458, the fourth line, but unquestionably, the president is not invested with arbitrary authority to recognize a stranger as successor to the Gaddi or not to recognize any person at all as a successor. The power of the president is plainly coupled with a duty to maintain the constitutional institution, the constitutional provisions, the constitutional scheme, and the sanctity of solemn agreements entered into by the predecessor of the union government, which are accepted, recognized, and incorporated in the Constitution. An order merely de-recognizing a ruler without providing for the continuation of the institution, which is an integral part of the constitutional scheme, is therefore plainly illegal. Because Madhav Rao was a judgment of a bench of 11 learned judges, and Justice J.C. Shah, His Lordship Justice J.C. Shah was speaking for 7 of himself and 6 other learned judges, for 7, the majority of 7. I think there were some concurring and some dissenting opinions. But I'm just placing this that these powers have to be exercised bona fide, and I don't see anything, certainly not in their counter, but there's no justification whatsoever for why these two provisos had to be suspended and what nexus that would have with the proclamation under 356. That's the first point. Now, may I just skip over the second point, that timeline? I'll come back to that. I've made just a one pager where I set out that timeline. I can come back to that since the question fell from my lords about the background to union territories and how they came about and so on, and what is their status in the constitutional scheme. Yeah. So this is if your lordships are kind enough to see what happened, I'll just summarize it and I'll take your lordship straight to the relevant provisions. 1905, Lord Curzon split the province of Bengal. This was done unilaterally as a Governor General. That led to the partition or bifurcation of Bengal, led to a tremendous backlash against the British Raj. And there were huge protests, a lot of killings, etc., etc. And ultimately, in 1911, Lord Hardinge was compelled to rescind that move and restore Bengal as one province. Now, this experience led to a declaration by the British Parliament on 20th of August 1917 to devolve greater power on India, and particularly on the provinces of India and the representatives of the people in those provinces. And this, your lordships will find, the declaration by Parliament led to the 1919 Act, the Government of India Act 1919, which specifically provided for the original precursor to Article 3. So the 1919 Act, along with that declaration, your lordship will find, volume 18 of the documents, and it's that proclamation, that declaration is very important, Lords, and as also the preamble to the 1919 Act. Volume 18, page 14, PDF 14, is the declaration of 20th August 1917.
Volume 18, page.
Volume 18, PDF 14, is the declaration of 1917, 20th August 1917. It's very short. May I read it, please? The policy of His Majesty's government with which the Government of India and complete accord.
Have you got it?
Page 14. I'm so sorry. Volume 18.
The Government of India Act 1919, right?
Yes.
You have section 3 there, 3.1.
Yes, but the declaration is at PDF 14. The declaration of 20th August 1917.
No, that's not at page 14.
Page 14 is the Government of India Act.
Volume 18, PDF 14.
No, that's 10849, which is the page you're getting.
10835.
Oh, 10835.
Yes, I don't know why my PDF. There must have been an earlier version. I'm so sorry. 10835. Does anybody have the correct page?
53.
What page is it?
I had it at PDF 14 because that was what was given to us.
10835.
The declaration of
20th of
the
August PDF.
Declaration of 20th August 1917.
PDF.
It starts with the policy of His Majesty's government, with which the Government of India are in complete accord.
PDF page 14. Yes, it's there.
We all have it as PDF 14. I think that
Yes, 835, right? It's 10835.
10835. And on this side, we all seem to have it at PDF 14. I don't know, there's some mismatch. My lord, find it now.
Yes, just one second. Mr. Nyalapula?
Yes. This is from extracted, this entire book is here in this volume, which is the Working Constitution in India by S.M. Bose, the 1921 publication.
Yes.
The policy
Yeah,
of His
just one second,
Majesty's
one
government,
second.
with which the government
Just one, Mr. 1 second.
Where's Prasanna? My Lord, Honorable Justice Suryakant finds it. I don't have a problem with PDF 58 also, but the section. Perfectly matched. There's some. I could hand up an iPad if for my lord. Your Lordship's Government, 10835, the running page. The declaration of 20th August, the policy of His Majesty's government, with which the government of India are in complete accord, is that the increasing association of Indians in every branch of the administration and the gradual development of self-governing institutions with a view to the progressive realization of responsible government in India as an integral part of the British Empire. They have decided that substantial steps in this direction should be taken as soon as possible, and that it is of the highest importance as a preliminary to considering what these steps should be, that there should be a free and informal exchange of opinion between those in authority at home and in India. His Majesty's government have accordingly decided, with His Majesty's approval, that I should accept the Viceroy's invitation to proceed to India to discuss these matters with the Viceroy and the government of India, to consider the Viceroy views and the views of local governments, and to receive with him the suggestions of representative bodies. I would add that progress in this policy can only be achieved by successive stages. The British government and the government of India, on whom the responsibility lies for the welfare and advancement of the Indian peoples must be judges of the time and measure of each advance, and they must be guided by the cooperation received. The progress, when your lordship sees the particular section, the preamble then was based on this of the Act in 1919, was 5 pages down. If your lordship just scrolls down 5 pages to the Government of India Act. Now, the preamble to the Act specifically said the 1919 Act, whereas it is a declared policy of Parliament to provide for the increasing association. So, based on this same declaration, there was the
Were the
period,
union,
then
were the
particular
UTs all
provision-
were the UTs all a part of the Part C territories?
So I'm just coming to that provision then straight away. If your lordships, I have it at PDF page 58.
And before the constitution came into force, where were these Part C territories comprised?
Yeah, so there
They were the chief commissioner's provinces.
yes, that's right. So there were the governor's provinces became Part A states. The Governor General and then later the governor. So Bombay province, Madras province, Calcutta, Fort William, etc., became the Part A states. The Indian states, which
Became Part B.
not all of them, there were 562 states, those which could be merged and made into viable states, because viability was the main crux here.
But J&K was also a Part B state.
That's right. So those which were viable as states, all Indian states which were viable either standing as they stood or by merger became Part B states. Those which were
Now, in the Government of
where
India Act, what was the classification of the territories in the Government of India Act?
Yeah, that in the Government of India Act, there were governors' provinces, there were chief commissioners' provinces, and I'll just show that.
So we must look at what was the position in the Government of India Act,
That's right.
how that transformed into the Constitution.
Yes.
So that will give us an idea of how the union territories were created.
Yes, and in fact, in the
The union
Constitution,
territories came into being. One thing is very clear: the union territories came into being with the Seventh Amendment in
Seventh Amendment.
1956.
So in the Seventh
That
Amendment,
abrogated the distinction between Part A, Part B, and Part C states and the Part D territories,
yes,
and then brought the entirety of India into the states and the union territories.
union territory. Now, so I'll just show your lordship the progression. So if your lordship sees here, please come straight away to PDF 58, which would be in this same volume. It's 10879 running page.
Page 58.
But your 58 won't match because 14 wasn't matching. Could your lordship tell me what was your equivalent PDF for 14?
The difference is 14 pages actually.
14 pages, 14 more. So this 58 would be 72, perhaps around 72, 1087. 10879. It should be a PDF 72 if there's a difference of 14 pages.
How does it start?
Section 14 is on the top. Government of India 10879 is the running page. The printed page number is 44 and it's PDF. We have PDF 58, all of us here.
PDF 72 is 10907.
109.
PDF 44.
Oh, it's 14 less then. So it should be 44, perhaps PDF 44. PDF 44 should work out. 43 or
You're referring to internal page 44. PDF is 58. Section 14 you're referring to.
Yes,
14, right?
we are getting PDF 58.
That is
internal page-
10879.
Yes.
That is page 44, I think.
No, that's page
Yeah,
44.
yeah,
PDF
yeah.
is page.
So your lordship's PDF is matching the internal page number, I think.
No.
Page.
So now 15.1. Which page? But on Actually, what I'm taking your lordships to is the precursors to Article 3. But to answer the union territory aspect, in my written submission, your lordship will find that.
So now we are at 10879 with a great effort. So let's focus on that. We don't lose this precious page.
So this is the precursor to Article 3 in the 1999 Act, Section 15.
Section 15.
Yes.
All right, let's see that.
And the marginal note is constitution of new provinces, etc., and the provisions as to backward track. The Governor General and Council may, now please note, after obtaining an expression of opinion from the local government and the local legislature affected. This is why I was reading that preamble and the declaration of the King, His Majesty. The Governor General may, after obtaining an expression of opinion from the local government and the local legislature affected, by notification with the sanction of His Majesty previously signified by the Secretary of State and Council, constitute a new governor's province or place part of a governor's province under the administration of a deputy governor to be appointed by the Governor General, and may in any such case apply with such modifications as appear necessary or desirable, all or any of the provisions of the Principal Act or this Act relating to governor's provinces or provinces under a lieutenant governor or chief commissioner to any such new province or part of a province.
Therefore, that is the power to constitute a new governor's province.
Yeah.
Yes.
And then subsection 2 deals with backward tracks. We are not concerned with that. This was then carried forward in section 290 of the 1935 Act.
Where is that?
That your lordships will find. Look, I'm sorry, in this, could your lordship just read the footnote to this? Section 15, there's a footnote of the committee report, which is very important. This is in the whole thing of self-governance. The footnote is on the next page. For constituting, the committee have two observations to make on the working of this clause. On the one hand, they do not think that any change in the boundaries of a province should be made without due consideration of the views of the Legislative Council of the province. On the other hand, they are of opinion that any clear request made by a majority of the members of a Legislative Council representing a distinctive racial or linguistic territorial unit for its constitution under this clause as a sub-province or a separate province should be taken as a prima facie case on the strength of which a commission of inquiry might be appointed by the Secretary of State, and that it should not be a bar to the appointment of such a commission of inquiry that the majority of the Legislative Council of the province in question is opposed to the request of the minority representing such a distinctive territorial unit.
Now,
This is that what I was saying about the arbiter, Parliament being an arbiter when there is within a state.
Where is the Government of India Act, section 290?
290, your lordships will find in volume 6, my lords, of the document, PDF 113, and I trust, my lords, this time we'll all be on the same page, my lords. Volume 6.
Volume 6.
Page?
Page 113, my lords. 290 is almost in the same form in which Article 3 came to be enacted by the Constituent Assembly.
What is the page?
Your lordships have page 113, PDF 113?
113.
Volume 6, no, document volume 6.
$290.
Creation of new provinces and alteration of boundaries of provinces.
Which is the, and how are the provinces distributed under the Government of India Act, actually?
Section 5 no, of this.
Yeah. 5 refer to? What is the PDF page for page?
PDF page 18, I'm very grateful to Mr. Shankaran.
18.
Yes, Proclamation of the Federation of India, PDF 18 of this same volume 6 minutes. Establishment of Federation and Accession of Indian States, Proclamation of Federation, it shall be lawful for His Majesty. May I read that? If an address in that behalf has been presented to him by each House of Parliament, and if the condition hereinafter mentioned is satisfied, to declare by proclamation that as therein appointed, There shall be united in a federation under the crown.
No, but it's kind of important because it says it shall comprise of the provinces, hereinafter called the governors' provinces, and the Indian states which have acceded or may thereafter accede to the federation. And in the federation so established, there shall be included the provinces hereinafter called the chief commissioners' provinces.
That's right. Then the conditions referred to is that states the rulers whereof will in accordance with the provisions contained in part 2 of the first schedule be entitled to choose not less than 52 members of council of state, and the aggregate population whereof as ascertained in accordance with the said provisions amounts to at least 1/2 of the total population of the state so ascertained have acceded to the federation. Then the manner of accession is in section 6. And the footnote notes to section 5. It says section 5 was substituted as follows. This is not the after 15th August 1947. I think this was in 1948.
This is important.
Government of India Act was.
So with the Indian Independence Act, we got the governors' provinces, the chief commissioners' provinces, the Indian states in the manner hereinafter provided, and any other areas that may be with the consent of the Dominion included in that Dominion.
Yes, and this was not under the Indian Independence Act. This was an amendment to the Government of India Act 1935.
Right. Following the Indian Independence.
Following the Indian Independence Act, absolutely. Because till then it was only the British Parliament which could enact the law. After 15th August 1947, the amendments were made by the in the Dominion by the Dominion.
Now, were the chief commissioners' provinces is referred to in any schedule to the Government of India Act or no?
Chief commissioners' provinces, no, I think it's in the 1919 Act, but just check in the 1990. Just check it. Page?
Page 49.
Oh, of this very thing?
Oh, I'm very grateful. Part 4, the Chief Commissioner's Provinces, correct. At PDF 49, my lords, have that? Section 94 onwards. My lord will find this, my lord, Honorable Justice Suryakant will find it
Yes.
PDF 49. Madam.
Yes. Good.
Part 4, the Chief Commissioner's Provinces. The following shall be the Chief Commissioner's Provinces, that is to say, the heretofore existing Chief Commissioner's Provinces of British Baluchistan, Delhi, Ajmer, Merwar, Kurg, and the Andaman and Nicobar Islands, the area known as Pant Piploda, and such other Chief Commissioner's Provinces as may be created under this Act. Aden shall cease to be a part of India. A Chief Commissioner's Province shall be administered by the Governor General, acting to such extent as he thinks fit through a Chief Commissioner to be appointed by him in his discretion. Then British Baluchistan is set out in
So
95.
now from here we go to the Constitution. Would it be correct to say that when the Constitution is adopted on 26th of January 1950, the territories were comprised into Part A states, which comprised of the governor's provinces, the erstwhile governor's provinces. Part B states, which were the Indian states which had acceded to the Dominion of India. Part C
No, only
states.
such of those which were viable.
Right, we're not now on the Jammu and Kashmir thing at all. We are now looking at the broad.
Yes.
So this argument is independent of the J&K issue.
Yes.
Part C states were the erstwhile chief commissioners' provinces.
Yes. And
Part D states were the other territories.
no, and Part C
Let's
state
look at
also had one more category.
Let's look at the Constitution as of 26th of January 1950, because that schedule will give us the distribution between what was Part A, what is Part B, Part C, and Part D.
Just one qualification.
That whole the Part C states had the Raj Pramukh.
That's right.
I think Part B also had the Raj Pramukh. Part C had the Raj Pramukh. Part A had the governors.
That's right.
And that continued from 1950 to 1956.
That's right.
56, following the Fazal Ali Commission, everything is abrogated and you just have states and union territories.
That's right. But just one small qualification. Part C states also included Indian states which were not able to be merged into a viable unit. So, for instance, Himachal Pradesh was consisting of 30 Indian states, 30 small Indian states. But because the province of Punjab, the governor state of Punjab came almost to the edge of Shimla at that time, there were hill areas of Punjab, and they automatically went as a part A state. So Himachal Pradesh, with its 30 states acceding and merging into it, still was not viable. So it was a part C state, though it was Indian states, but part C. So there were several such cases of those which were not viable as independent statehood at that point in time. It became a part C state. It became a union territory in 1956. Then in 1966, when Punjab demanded a Punjabi Suba, and there was a huge movement and agitation, etc., as a negotiation to give Punjab a linguistic state, Haryana was carved out, and the hill areas of Punjab were carved out and given to Himachal. It still continued temporarily as a UT, and in 1971 it was made into a full state.
Now, do we have the constitution, just to complete the whole exercise?
Yes.
The constitution as of 26 January 1950, where is that?
Yeah.
Yeah, they can put it on the screen.
All right, they'll put it on the screen actually.
If your lordship, in the meantime, may I just very quickly take your lordship to my written submission, a very brief thing on how this transition took place, page 468 of my written submission.
So, Mr. C, you're saying at the time when Punjab, the division of Punjab took place, there were two union territories. Himachal Pradesh was carved out as a union,
And Chandigarh,
and Chandigarh was carved
because
out.
because of the,
Correct. There were two union
That's
territories
right.
which were carved out.
that's right. That's right. Absolutely, your lordships are right. In fact, this is all in my note, but even in the written submission. But the point here is, right from the 1919 Act, the progression has been consistently and continuously towards greater self-governance, and greater self-governance in the form of full statehood.
We are only on today, for that, the question is legality of that order in terms of Article 3.
That's right. That's right. So, but the context in which the reading that I would seek to persuade your lordships to adopt is one which would be consistent with that objective of greater self-governance. When we read Article 3 as opposed to Article 368, that greater self-governance and the move that, because keep in mind that barring these small, unviable or special status union territories, Delhi, Chandigarh, Andaman and Nicobar, Dadra and Nagar Haveli, etc., by 4th of August 2019, there were only 7 union territories left in India. And the 7 were Delhi, Chandigarh, Andaman and Nicobar, Dadra and Nagar Haveli, Daman and Diu, and Puducherry and Puducherry. These were the 7 union territories left. All others were merged or amalgamated.
Now see what they have put up on, it's very interesting. Part A, this is on the date of the constitution. Part A states are basically 9 states. Assam, Bihar, Bombay, Madhya Pradesh, Madras, Orissa, Punjab, United Provinces and West Bengal.
That's right.
Now let's see part B, thoda sa scroll kar lijiye.
Part B.
We get this.
ये कहाँ से मिला आपको? अच्छा, गोपाल के.
Part B states,
Now part B are Hyderabad,
Jammu and Kashmir, Madhya Bharat, Mysore, Patiala and the East Punjab states, that's the PEPSU, Patiala and East Punjab States Union, Rajasthan, Saurashtra, Travancore, Cochin and Vindhya Pradesh.
right?
Then your lordship sees the territories of the state. The territory of each of the states in this part shall comprise the territory which immediately
थोड़ा
before
scroll
the
कर लीजिए.
commencement of the constitution
थोड़ा
was
सा ऊपर
comprised
कर लीजिए.
in the corresponding Indian state, and in the case of each of the states of Rajasthan and
थोड़ा ऊपर
Saurashtra
कर
shall
लीजिए.
also comprise.
जम्मू एंड कश्मीर का टेरिटरी देख लेते हैं क्या है. थोड़ा सा ऊपर कर लीजिए. और जाइए ऊपर. थोड़ा नीचे. नहीं, ऊपर ऊपर.
Now your lordships will see that some of those commissioners' provinces
ऊपर जाइए आप.
were merged into Part B states because they became
Part
viable.
states
Pipoda,
are- हाँ, वहीं पर. Ajmer, Bhopal, Bilaspur, Kuch Bihar, Coorg, Delhi, Himachal Pradesh, Kutch, Manipur and Tripura.
Himachal Pradesh was at that time also,
Part C में था.
was it not included in Punjab?
Yeah, yeah.
It was later on included in Punjab.
And ऊपर जाइए थोड़ा सा.
Punjab was.
And then part
Now,
C.
if your lordships come to part C state,
The second paragraph of each of these parts in the schedule describes what they were earlier. If your lordship sees part A, part B, part C, they have explanations below the list. No, it's there. It's
yes,
part of this.
if your lordship just goes below part B, territories of states,
Below the list, these territories, they have for each of the parts. Now, the second explanation there describes where they came from.
beneath each of the lists, the territories are given, and that shows how different units were merged into them even on the beginning of the constitution.
Right.
I have also got a table in my
And part D only comprised of Andaman and Nicobar.
Andaman and Nicobar, which was a chief commissioner's province in the 1935 Act. But that was carved out separately.
of Ladakh as a UT and the change of status from a state to a UT of Jammu and Kashmir.
Yes, Milad.
Both aspects.
Both. First of all, just the conversion of a state into a union territory, I submit, is only if at all it could be done. I submit it violates the basic structures. It can't even be done under Article 368. But if at all it could be done only under Article 368 because it clearly impinges on at least 6 or 7 provisions in the proviso. So it would require both the special majority and ratification by more than the legislatures of more than 50% of the states to convert a state into a union territory, and I'll make good that submission.
Therefore, I refer to two different things. Carving the change of status is one, and suppose Jammu and Kashmir assembly status was maintained and only UT was carved out, then what would be argued?
Even so, Manoj, the submission really is that for Ladakh and for Jammu and Kashmir, the exercise which has been done is one which is clearly beyond the purview of Article 3. It was not permissible under Article 3 at all, even if it had been rightly done. I'll show from the timeline that it's actually not even done as per Article 3. But assuming it were rightly done under Article 3, this is not the scope of the power of Article 3. When I take your lordships through the provisions of the Constitution, your lordship will see Article 295, Article 294, etc. A state comes with property or lands, property, consolidated fund, rights, contracts, right to raise money. It has absolutely sacrosanct powers under Article 73, read with Article 162. The executive powers, the legislative powers.
Your 1 hour, how long would you now take?
Look, I'll try to be as brief as possible. I think it will take about an hour or so.
No. 1 hour, no, Mr.
Look,
can't be 1 hour. Can't be.
I'll tell you, Lordship, this is what I'm arguing is something nobody else has argued. But the main thing here is we are saying that regardless of what
is the point of this chart then?
Look, independent.
You're supposed to have a kind of arguing discussion.
Look,
1 hour, you take 2 hours, then this schedule means nothing.
Look, I acceded to your lordship wishes and I confined myself from day one. I adopted other people's arguments. I'm not touching on 370 at all. I'm saying that and if at any stage your lordships feel that I'm going beyond the purview of there are the 4 or 5 points which I outlined at the beginning.
You've made your 4 points, but you have made your 4 points now, and your argument really is this. That look, insofar as the twofold, you cannot convert an area which is comprised in a state into a union territory. Now we have seen the history of the creation of the union territories.
Yes.
Because when you create a union territory, we've also, the people who have preceded you, they have said that, look, the whole essence of a state is democracy. You have a legislature, you have elections, you have converted it into a union territory which has no legislature, which has no elections over the past 4 years. Therefore, that's one aspect. The second
And
aspect.
the large bulk
And the
of
second
the
aspect
state
of your
has become a
submission
union territory without a
is that
legislature
I
altogether.
think the second aspect of your submission is that you can't use the Article 356 power to suspend the two provisos to Article 3 and then use that to complete the process of conversion of these states into union. So these are the two key areas really. I think we can give you another 10 minutes.
I'll go with, no, I won't be able to do it in 10 minutes. And I think your lordship will perhaps accept my submission.
Actually, Mr. Singh,
That there are some.
everybody has argued this point also before.
Not a single,
Just that.
Lord, I will not repeat a single argument that anybody's made. I'll take your lordship
Right.
very.
3 to 3:15. We'll give you 15 minutes, I think.
Lord, I'll go as quickly as I can.
Minutes and that's it. Now,
I don't think I'll be able to do that. No, then
Mr. Singh, advisor.
I'll go very quickly, Milord. I will not take extra time on anything. I'll just go point wise and place the
Because
relevant pages.
tomorrow they have to start arguing. Between all of you, we decide now, we'll give you a little more time, but it will cut into somebody else's time. So who that person is, you please decide for yourself.
No, I think that that may not be proper in this case.
Delimitation, for instance, we are not concerned with delimitation here. Delimitation is not an issue in these petitions. So we have to now, the delimitation argument, Dr.
No, I'm not arguing on delimitation.
No, that what we are trying to say is that at lunch, you reorganize the time between yourselves because delimitation will not arise at all in this.
I think your lordship may need to give us a little bit of time tomorrow, a little bit of time.
No. We'll conclude today of all this ideas. Mr. Singh, one request. I'll tell you why we were trying to put a little time limit now. With all the hard work which has been done by your side, I think, we have reached a point of mental saturation, not fatigue. But mental saturation where we are now, there are questions to be posed to the other side and answers to be required from the other side.
Yeah.
So in that sense, conscious as we are that if we are putting an end to your argument a little earlier, on the reorganization, we'll bear that in mind so that when they respond and it comes to the rejoinder, we'll give you a little more time in the rejoinder because then you will have to really deal with what their defense is.
Yeah.
Because broadly, reorganization was argued before you also, though you've put it in a different way. We have seen the provisions now. We would now like to be in a situation where we conclude this part and we sort of, we have questions to the other, to be posed to the other side. We have to demand answers from them. And we're now at a point in the matter where, you want now to move on. That's the only thing. I mean, it shouldn't be misconstrued why are we sort of curbing arguments.
No, I'm conscious of the anxiety of the court.
6, 7 council lifetime. It is such a matter which has such no ramifications. So
Yeah.
just some kindness from your lordship.
Okay. Yes.
And leave you.
So
Yes, Mr. Singh.
I'll just summarize the point on the union territory
Yes.
aspect. I have, in fact, in my written submission, I've got a detailed note on it. I'll just flag that to your lordships. Let me just summarize it, in 3 or 4 sentences.
Yes.
That's all. So basically, the point is this: that the history of Articles 3 and 4, emanating from the 1919 and 1935 Government of India Acts.
Just one second, Mr. The history of Articles 3 and 4 emanating from the
1919 and 1935 Government of India Acts shows that the powers to alter boundaries, change names, etc., was always used to increase self-representation and democratic self-government.
under
And there
Article
was no case of retrogression.
was used to
Increase democratic self-government and self-representation, and there was no case of retrogression. Secondly, my lords,
just one second. Yes.
these powers were always exercised after due democratic consultation with the people of the concerned region, state, or territory. And this, your lordship will find in my written submissions. My written submissions were that PDF 445 of
We
the
won't say with the people of the territory, we'll say with the legislative representatives of the territory.
people of the territory through their representatives, which is why I showed your lordships the section 15. Which is why I showed your lordship the footnote to section 15, the committee report which led to section 15 of the 1919 Act. Lordships recall that the committee report and what they said about the consultation. Similarly, the 1935 Act, and then, lords, and in my written submission, which is that these points are made out. I'm just summarizing it. At page 445 of the combined written submissions is my written submission, PDF 445. From pages 464 to 472, I deal with this history and progression of union territories. 464 to 472. I'm not even taking your lordships through it. I'm just identifying it for your lordship. In particularly, my lords, paras 41 to 43, a note may be made of this. I've set out a chart of how various territories changed from Part C state to union territory, Part C state to union territory to full statehood, etc., etc. And that's why I was, the way I would sum it up is that when your lordships see Schedule 1 to the Constitution and the section on union territories, my lords will find that today there are only 6. I mean, take away Jammu and Kashmir, because even Dadra and Nagar Haveli and Daman and Diu have been merged into one in 2020. They've been merged into, they've been made into one unit. Even though because there are 4 small parts, 800 kilometers this side, 400 kilometers that side, etc., etc. Because between Daman and Diu, it's an 800 kilometer driving distance. I mean, not flying, but if you drive down the down the run of Kutch, etc. So, so these small non-viable territories have remained, which are not viable as states, have remained as union territories. None other. All have gone in one direction. So this your lordship will find in my note. I'll say no more about this. No, that's done. Now coming to the next point, lords, is that 3 and 4 have to be read. First of all, I said that 3 and 4 have to be read as part of part 1. Now part 1 is very important because your lordships have been showed Article 1 and 2. Article 1 says India shall be a union of states. Article 1 was amended by the 7th Amendment when union territories came to be introduced. But Article 1.1 and 1.2 were not amended. Union territories were added in 1.3. Sorry, in 1.3b. So even while amending in the 7th Amendment, India, that is Bharat, shall be a union of states. The territory, the states and the territories thereof shall be as specified in the first schedule. These were not amended when union territories came into being in the 7th Amendment. What is added is 3. The territory of India shall comprise A, the territories of the states, B, the union territories specified in the first schedule, and C, such other territories. But the basic concept of India, that is Bharat shall be a union of states, was maintained. Article 2 was maintained as it is. Admission or establishment of new states. Parliament may, by law, admit into the union or establish new states on such terms and conditions as it thinks fit. Article 3 was not amended till the 18th Amendment, when those 2 explanations were inserted. Now the explanation has become the tail which is wagging the dog. And from that it is sought to be contended by the union that because the explanation says for certain portions the state shall include union territory, therefore any permutation and combination is now available to Parliament under Article 3. Now, keeping aside the fact that the two explanations were never extended to Jammu and Kashmir. The two explanations which were introduced by the 18th Amendment were never applied to Jammu and Kashmir.
Just one second.
I'll
Yeah,
come back to
make
that,
that
keeping that aside for the moment. So this fiction that you can convert a state into a union territory was, by the Constitution of India, never applied to Jammu and Kashmir. But keeping that aside for a moment, because I'll come to that on that timeline issue. Now, please see the enormity of it if you accept this argument for a moment of converting states into union territories as a whole, and for the whole of the country, including Jammu and Kashmir, because we are saying that it's an integral part of India. Please see Article 294 and 295 may just be seen. These particular articles I want to show because my Lord the Honorable Chief Justice wanted to know how are these provinces dealt with by the Constitution of India. So under 294, those properties of His Majesty's government, which were used for the dominion, became part of the union properties. Please see 294A. All property and assets which immediately before such commencement were vested in His Majesty for the purposes of the government of the Dominion of India, and all property and assets which immediately before such commencement were vested in His Majesty for the purpose of the government of each governor's province shall vest respectively in the union and the corresponding state. So properties which were for the Dominion vested in the Union of India, properties which were for a governor's state, which were being used for a governor's state, vested in the corresponding state. Punjab, Bombay state, Madras state, etc., etc. The properties pertaining to that state vested in the state by constitution. Similarly, all rights and liabilities, etc., again, respectively in B. Then 295, succession to properties, assets, and in other cases. Now, please see 2. Sub 2, I'm just taking a lot. This is now dealing with the Indian state. Subject is aforesaid, the government of each state specified in Part B of the first schedule shall, as from the commencement of this constitution, be the successor of the government of the corresponding Indian state as regards all property and assets and all rights and liabilities and obligations that are arising out of any contract or otherwise, other than those referred to in clause 1.
Yes.
So those properties became the Part B state's properties. Part C and Part D were not defined here because the union had control of them. The union had control of Part C and Part D, so they remained in a sort of a silo. Because what really happened is Part C and Part D and union territories are really a stepping stone. It's a silo kept as sort of a holding pen, so to speak, till you can get full statehood. The holding pen, the silo in which you're kept safe and secure under the benign umbrella of the Union of India. It's really for that. It was never intended.
And Mr. Singh, anyway, Mr. Nafde,
I'll just put this point.
Mr. Nafde, in the concluding part of his submissions, has given us a whole list of what the impact on the constitutional structure is. And we have made note of that. 1, he said Ladakh has no representation in the Rajya Sabha. 2, Rajya Sabha, all of the 4 seats go to J&K. 3, Lok Sabha, Article 81C. All UTs can have a maximum of 20 seats. Article 81(2), other states' seats depend on population. J&K has no proportional representation in the Lok Sabha. Presidential election, Article 54 and 55. Yes. J&K, no MLA for presidential election. The Reorganization of Act of 2019 gives the same rights as Puducherry. 279A, no representation in the GST Council, and High Court judges, no views of the CM are taken.
I'll just add a few more. I won't take your lordship to the sections. I wanted to show this section just to show how property and rights devolved. Now I'll just mention a few more. Under Article 266, provides for the consolidated fund of the union and a separate consolidated fund of the states. 261 and 2. 283(2) provides for the custody of the consolidated fund of the state and the manner of withdrawal from that custody. 289 exempts the property and income of a state from union taxation. 283, 162, now this is very important, 162 says, subject to the provisions of this constitution, the executive powers of the state shall vest in the state in respect of list 2 and list 3. List 3 only if Parliament makes a specific provision by a law to exercise executive powers in respect of some particular provision of list 3, executive powers now I'm talking about, only then to that extent the state will yield executive powers to the union. Otherwise, all executive powers in the state on subjects of list 2 and list 3 are exercised by the state. And this is not subject to a law made by parliament. This is subject to the provisions of this constitution. The reason it is subject is that 256, 257 are a qualifier on 162. 256, 257 is where the union, for purposes of defense, etc., can encroach to some extent on the powers of the state. 73 is the concomitant executive powers of the union. 73 has please just see that, 73 has a specific provision which says the union shall not exercise any of the powers of the state. 73, subject to the provisions of this constitution, again, not by law, the executive power of the union shall extend to matters with respect to which parliament has the power to make laws and to the exercise of such rights, authority and jurisdiction.
The proviso.
Now, proviso, provided that the executive power referred to in subclause A shall not, save as expressly provided in this constitution or in any law made by parliament, extend in any state to matters with respect to which the legislature of the state has also powers to make law.
The proviso to 73 and the proviso to 162 are mirror images.
Mirror images.
Because the executive power of the state also extends to laws, to concurrent field subjects.
That's right.
And including any law made by parliament in the concurrent list, unless parliament expressly reserves the power to the union government.
That's right. That's right. Absolutely right. Then verse 293 further clarifies that the executive power of the state extends to domestic borrowings against the consolidated fund of the state. So there's a specific constitutional power of that. 298 extends the executive power of the state to carrying on trade or business, acquiring properties, etc.
All right, Mr. Singh.
And then 246 and the lists.
Yes.
Now, by a simple expedient of a simple ordinary majority under Article 3, all these constitutional rights, many of which are directly part of the basic structure of the Constitution, are wiped out. So, the theory is...
Point is taken, Mr. Singh.
No, this has been dealt with by your lordships, fortunately, and I want to just place that. Following, if your lordships are kind enough just to see the judgment of a constitutional bench in Shankari. Where's that one? All displayed. So, if my lords are kind enough to take up Shankari Prasad, I'd ask the learned court master to keep it ready. It's on the screen. This is AR 1951 SC 458, and His Lordship Justice Patanjali Shastri, speaking for the bench, spoke of harmonious interpretation of the different modes of amendment under the Constitution. If your Lordships come to para 6, on the first point it was submitted, and then overleaf, let's come to the last about 8 lines of para 6. Various methods of constitutional amendment. Do your Lordships find that one? Various methods of constitutional amendment have been adopted in written constitutions, such as by referendum, by a special convention, by legislation under a special procedure, and so on. But which of these methods the framers of the Indian Constitution have adopted must be ascertained from the relevant provisions of the Constitution itself, without any leaning based on a priori grounds or the analogy of other constitutions in favor of one method in preference to another. We accordingly turn to the provisions dealing with constitutional amendments. Now, the Constitution provides for 3 classes of amendments of its provisions. First, those that can be effected by a bare majority, such as that required for the passing of any ordinary law. The amendments contemplated in Articles 4, 169 and 240 fall within this class, and they are specifically excluded from the purview of Article 368. Secondly, those that can be effected by a special majority as laid down in Article 368. All constitutional amendments other than those referred to above come within this category and must be effected by a majority of the total membership of each house, as well as by a majority of not less than 2/3 of the members of that house present and voting. And thirdly, those that require, in addition to the special majority above mentioned, ratification by resolutions passed by not less than 1/2 of the states specified in Part A and Part B of the first schedule, This class comprises amendments that seek to make any change in the provision referred to in the proviso to Article 368. This is what my learned friend Mr. Nafde highlighted, some of those provisions which directly fall within A to E of the proviso. It will be seen that the power of effecting the first class of amendments is explicitly conferred on Parliament, that is to say the two houses of Parliament and the President. This would lead one to suppose, in the absence of a clear indication to the contrary, that the power of effecting the other two classes of amendments has also been conferred on the same body, Parliament, for the requirement of a different majority, which is merely procedural, can itself be no reason of entrusting the power to a different body and examine it. Because the argument here was being made that a constitutional amendment can't be made by Parliament, it has to go back to a constituent assembly. So that was a negative. Now, Milord, this was followed in Sajjan Singh. This Shankari dealt with the First Amendment, and Sajjan Singh dealt with the 17th Amendment, Milord, that is AR 1965 SC 845. And para 7, 8, please just see the first 4 lines of para 7 in Sajjan Singh. In our opinion, my lord, have that? In our opinion, the two parts of Article 368 must, on a reasonable construction, be harmonized with each other in the sense that the scope and effect of either of them should not be allowed to be unduly reduced or enlarged. Then in para 8, milords, about line 7 from the top, in other words, in construing both the parts of Article 368, the rule of harmonious construction requires that if the direct effect of the amendment of fundamental rights is to make a substantial inroad on the High Court's powers under Article 226, it would become necessary to consider whether the proviso would cover such a case or not. If the effect of the amendment made in the fundamental rights on the powers of the High Courts prescribed by 226 is indirect, incidental, or is otherwise of an insignificant order, it may be that the proviso will not apply. In other words, you have to harmonize these two provisions, and if it is substantially falling within, impinging on those A to E of the proviso, then you have to follow the greater. Then come to para 30, milords, of this.
So we'll see that, Mr. Singh. This is well settled. We'll have a look at it.
Very well. I only want to point out para 30, milords, because para 30 deals with Article 4 directly. So I would request your lordship, para 30. Incidentally, we may also refer to the fact that the constitution makers had taken the precaution to indicate that some amendments should not be treated as amendments of the Constitution for the purpose of Article 368. Take, for instance, Article 4.2, which deals with law made by virtue of Article 4.1. Article 4.2 provides that no such law shall be deemed to be an amendment of the Constitution for the purposes of Article 368. Similarly, Article 169.3 provides that any law in respect of the amendment of the existing legislative apparatus by the abolition or creation of legislative councils in states shall not be deemed to be an amendment of the Constitution for the purposes of 368. In other words, laws falling within the purview of Articles 4.2 and 169.3 need not be passed subject to the restrictions imposed by Article 368, even though in effect they may amount to the amendment of the relevant provisions of the Constitution. So they say that these provisions have to be read harmoniously, as in the Shankari, and they are exempted. But the exemption can't mean that you completely efface if you are falling within 368, to efface, my lord, the provisions there. Now, as it happens, my lord, this is, if your lordship just goes very quickly, my lord, to the Constituent Assembly debates for a moment, I just want to show your lordship Dr. Ambedkar on this, his speech on this very same provision, and why this ascending power of amendment, and how it has to, each one has to apply only in their limited sphere. So if your lordship sees volume 8 of the documents, and at page 881, this is Dr. Ambedkar's speech, begins at the previous page 880, dealing with Article 304, the draft Article 304, which is 368. Now, para 4, my lords, on page 881. Now let me turn to the provision of our Constitution. What is it that we propose to do with regard to the amendment of our Constitution? We propose to divide the various articles of the Constitution into 3 categories. In one category, we have placed certain articles which would be open to amendment by Parliament by a simple majority. That fact, unfortunately, has not been noticed by reason of the fact that mention of this matter has not been made in Article 304, but in different other articles of the Constitution. Let me refer to some of them. Take, for instance, Articles 2 and 3, which deal with the states. So far as the creation of new states is concerned, or the reconstitution of existing states is concerned, this is a matter which can be done by Parliament by a simple majority. Similarly, take, for example, Article 148A, which deals with the upper chambers in the provinces. Parliament has been given perfect freedom to either abolish the upper chambers or to create new second chambers in provinces which do not now have them by a simple majority. Now take Article 213, which deals with the states in Part 2. With regard to the constitution of the states, the draft constitution also leaves the making of the constitution of states in Part 2 and their modification to Parliament.
Nothing much turns on this really.
No, the harmonious reading, if your lordships.
That's well settled. Why do we have to read the speech for that?
I'm sorry, Milord?
We don't have to read the speech to have harmonious construction.
No, I'm only on this. What Justice Patanjali Shastri, the formulation that he made in Shankari, actually.
The three provisions: bare majority, 2/3 majority, and 2/3 majority with ratification. Those are the three separate provisions.
Just see page 882 for a moment. I'll just flag it. Your Lordship may just flag it. The third para in 82. Now, what is it we do? And the next para below that, after the interjection by the President. Yes, now we have no doubt put certain articles in a third category where for the purposes of amendment, the mechanism is somewhat different or double. It requires 2/3 majority plus
ratification.
I shall explain why we think that in case of certain articles, it is desirable to adopt this procedure. If members of the House who are interested in this matter are to examine the articles that have been put under the proviso, they will find that they refer not merely to the center, but to the relations between the center and the provinces. We cannot forget the fact that while we have in a large number of cases invaded provincial autonomy, we still intend and have as a matter of fact seen to it that the federal structure of the Constitution remains fundamentally unaltered. We have by our laws given certain rights to provinces and reserved certain rights to the center. We have distributed legislative authority, we have distributed executive authority, and we have distributed administrative authority. Obviously, to say that even those articles of the Constitution which pertain to the administrative, legislative, and other powers. It 28283. It's very important because it specifically deals with 73 and 162, the articles which were 60 and 142. And it says that these cannot be changed. This ratio, this balance cannot be changed except by a special majority coupled with ratification by more than half the states. So that may be just noted. Now in Mangal Singh, this is reiterated, and I'll just give your lordship the pages now. Mangal Singh, your lordships will find at volume 6, PDF 386, para 6.
Yes.
And in state of Himachal Pradesh versus Union of India, volume 14, PDF 776.
Volume number?
14.
Volume 14, PDF 776, para 93. And this is very important, Lord, if I can just draw your lordship's attention to it. Specifically, the Supreme Court held, my lords, in this judgment, what is not permissible under, my lords, Article 3 and 4. If your lordships are kind enough just to turn to volume 14, page 776. Para 93. We find, my lord, have that? Volume 14, page 776, para 93. We find that under the provisions of Article 3 of the Constitution, Parliament has the power to form a new state by separation of territory from any state, or by uniting two or more states or parts of states, or by uniting any territory to a part of any state, increase the area of any state, diminish the area of any state, alter the boundaries of any state, and alter the name of any state. But under Article 3, Parliament cannot take away the powers of the state executive or the state legislature in respect of matters enumerated in List 2 of the 7th schedule to the Constitution. This has been made clear in the speech of Dr. Ambedkar in the Constituent Assembly, quoted in paragraph 52 of the decision of this court in Kuldeep Nair versus Union of India. Relevant portion from the speech is quoted. The basic principle of federalism is that legislative and executive authority is partitioned between the center and the states, not by any law to be made by the center, but by the Constitution itself. This is what the Constitution does. The states under our Constitution are in no way dependent upon the center for their legislative or executive authority. The center and the states are co-equal in this matter. And then, my lords, your lordships have been shown Berubari in volume 13, page 492. Various paras, but my lord may just note the paras in Berubari, volume 13. It starts at page 492, paras 36, 38, 44, and especially 46 are very important. Then, my lords, R.C. Podial, etc., your lordships have been shown those. I won't. So,
Just reeling of judgments.
I'm so sorry.
Just reeling of the judgments and giving para numbers, doesn't it form a part of your synopsis? If it forms a part of your synopsis, we will give a consideration to it.
Well,
Otherwise, what's happening is you're depriving your other colleagues of a right to.
Because of in the context of that this could only have been done under 368(2). That is the essence. Now, the last point, and I will close, is what the second point I had raised, but my Lord, the Honorable Chief Justice wanted me to address on union territories to start with. So this is with regard to the timeline and how there was no power at all to table or enact this law at all in the manner in which it has been done. The reorganization. Please just take this timeline.
Exactly.
How Parliament passes it, does it fall within?
No, if there was, the point here is if it is, if CO 273 was not there and the Constitution of Jammu and Kashmir and the Constitution of India as applicable in Jammu and Kashmir was in force, this could not have been tabled at all.
Trying to say there's not inadequate debate, how the Parliament was conducted, this would be a difficult area to get. We understood the other propositions, but now to say, well, they did it in this much time.
No, if
done it not this much time, but this much time.
No. Let me put. I'm sorry. It's my fault. No, I have not made the point clear. If Article 3 says, for instance, that it will not be introduced unless the president has done ABC, and it is apparent that the president has not done ABC. ABC gets done on the subsequent date. It's not there on that date. Rajya Sabha passes a bill which it is not competent to pass at all, not competent to even table or consider under the terms of the Constitution. Then that's all I'm trying to point out. Please just take a look at this. It's a very short, just a timeline of 5 entries of what happened on 5th and 6th. This is all from available in the, and I've given the PDF pages of each of the documents.
Just give us, what are the dates? You can tell us the dates. Just give us the dates.
Your Lordship,
We'll not be able to handle these sheets now. We've got everything in the soft form. I mean, these sheets will just fly around the place.
It just gives PDF pages. Very well.
This will be a part of our record.
Now, on 5th August 2019, CO 272 is issued by the President, which adds subclause D to clause 4 of Article 370. Substituting the Legislative Assembly.
Heading?
That might save your lordships a little time if I can just
handle it.
It's not part of your synopsis. That's what I'm asking.
It must be part of your submissions, right?
It's part of your submission.
The written submission.
No, this timeline is not set out. This is all. It's in the COs and the what is in volume 3.
It's like a supplementary submission now being sought.
You don't want to, otherwise it will become
exactly
impossible.
It's not a submission. I can take your lordships directly to the documents. It's not a.
So just tell us now quickly the dates so that we can wrap up now.
So when CO 272 is issued by the president. This merely adds a subclause D, which substitutes the legislative assembly for the constituent assembly of the state. On the same day, this is at volume 3, page 101.
To our side.
Let me close with that. We'll go through this.
Now, on the same day, the second entry, the Lok Sabha, on a reference from the president, this is the phraseology, passes a resolution to accept the J&K reorganization bill presented to it by the president for its views. Now, this is at volume 3, page 104. I'll tell you, Lordship, the importance of this.
We'll have a look at it. Yes.
Let me just make the point.
What's the point of doing this? See, you please tell us if we will not go beyond 4 o'clock. You ask your colleagues whether it's fair to them or not. That's all I'm saying.
May I just summarize the point in a few sentences?
1 hour was taken. We've given you 1 hour, 45 minutes. Still you feel something more has to be done.
50 minutes.
This is not fair, honestly.
If your lordships have felt that I have repeated myself in any way or not
Everybody
been
has to ration time. Everybody has to ration time, you know.
We have given you time. We have summarized it. At some stage, all good things must come to an end. The arguments must come to an end. Let us have the next council now to address this.
Let me just make the point in 2 sentences, Mr.
Yeah.
The point here is that under the 2 explanations did not apply to Jammu and Kashmir until CO 273 got passed on the following day, and it was only recommended simultaneously along with the Rajya Sabha passing the Lok Sabha passing the J&K Reorganization Act. This is not permissible because until then the Constitution of India as applicable to Jammu and Kashmir applied. The explanations were not there. Union territories were not in Article 3 as it applied to Jammu and Kashmir. So I'm saying that what was tabled and what was passed by the Rajya Sabha purportedly on 5th of August was something clearly contrary to Article 3 itself. So if they are founding their case on Article 3, I submit that is ultra virus. That's the point.
Thank you.
Thank you, Mr. Singh. Mr. Parekh? He'll walk down.
Because I'm very grateful that.
Thank you, Mr. You be arguing?
I'm conscious of, my lord, the time constraint. I must indicate, my lord, what I am going to argue. I am going to argue, my lord, one point with regard to the historical details, which has not come in, my lord, so far. The list of dates which was given, which is manifesto of 1944. I am going to say something about, my lord, 370. And then, my lord, about the governor's, my lord, proclamation and the presidential order. That's how, my lord. And I know I am not going to repeat. And I'm conscious, my lord, because in Bhopal case, when I appeared before Justice Call, he said you have to summarize. So I am trained, my lord. I am trained in that.
10 minutes, please summarize the point.
10 minutes I can, my lord. But
we have to wrap up by 4 o'clock. Everybody has time until 4 o'clock.
This is what happens. Somebody who is, my lord, sensible, then he is put into this difficulty.
Everybody is, Mr. Parekh. We'll now wrap up. Just formulate it. Just tell us.
I'll do my best.
Just formulate it. We'll take it down. Yes.
I am going, my lord. Now, the first point is, my lord, the historical details, which is, my lord, the manifesto of 1944, which is important.
Why don't you formulate
just, my lord, I am appearing in repetition number, lordship will just note, 1368 of 2019. And my written submissions are from page 504 in volume 1 of the submissions. Now, my lord, the formulation is like this. That, my lord, the people of Kashmir on 29th, 30th of September 1944 came together and gave themselves, my lord, a manifesto. In manifesto, they said two things we want. We want a constitution for for Kashmir, and then also an economic plan for Kashmir. Now, these two things were there. Then they went into the question of, my lord, what rights should be given to the children, what rights should be given to the women, what kind of land reform should be there. All that was part of manifesto. Now they gave it to my lord, to the Raja at the time, and then Maharaja. And Maharaja, for consideration that this is what we demand, and this is the democratic setup we want in Kashmir. Now, this particular manifesto, which, my lord, is taken as a Magna Carta, virtually, and that's what, my lord, Justice Anand says in his book on Constitution, was then accepted in the Constitution, and whatever people said ultimately in the manifesto, most of it, my lord, was included in the Constitution. This is known as, my lord, the new Kashmir, they call this manifesto. Now, the importance is this, my lord, that the sovereignty rests with the people and they express, my lord, their sovereignty in a particular way. This is what they want. This is kind of democratic setup they want. Now, this sovereignty was, my lord, accepted when the Constituent Assembly was sitting and was translated, my lord, ultimately into the Constitution of Jammu and Kashmir. So there are two things, my lord, which emanate from it. Number one is that the sovereignty which vests with the people, and they, my lord, expressed it, and that expression was translated ultimately, my lord, into the Constitution which they gave unto themselves. That's number one. Second is, my lord, when there is a written Constitution, then that written Constitution is supreme. Now, lordships have, my lord, noted that judgment in Article 143, that privilege case, my lord. I'll just give the citation and the para number, which says, my lord, that ultimately in a democratic country having written Constitution, it is the Constitution which is supreme and sovereign. That is, my lord, 1965, 1 SCR 414, and it is in volume 17, PDF. It starts at 337 at 357, para 40. Para 103. Note that in my submissions, because it has not come. Now, my lord, the second judgment which I just wanted to draw your lordship's attention is, my lord, Bhumai's case, which has been cited before lordships. It is para.
So what's the, if you can conceptualize it, Mr.
The conceptual, my lord, that's what I'm saying. I'm saying that this, my lord, the entire idea, people said they want to have a democratic setup. And therefore they came together, gave themselves, my lord, a manifesto. Manifesto was translation of their wishes or desires, that it should be in a particular way. That, my lord, was given to Maharaja at that particular point of time, that please accept it because we want this monarchy to end, we want a democracy to come. So this expression, my lord, which was given in the manifesto, was translated ultimately, because as I said, it was a Magna Carta, and in the discussion also we find
that
they have
is in your
lordship,
submission.
So therefore the idea is
that Parikh, we look at your submission.
I know lordship said formulated. So it's, my lord, ultimately the sovereignty which vests in the people, ultimately transferred, my lord, in the Constitution. As I said, the Constitution is supreme and sovereign. My lord, that's the idea. And I, my lord, refer to the two paragraphs. One is, my lord, in the 1965 judgment, which is para 40, and para 102 and 103. So Justice Sawant's, my lord, view in Bhumai, and if your lordships permit me, I'll read only para 103 and this particular part will end. In this connection, may I give your lordship the PDF?
No, we got it, yes.
Yes. This will be PDF 171, 172 of Case Law Volume 2. 272? 271, 272. Now 102. Now 102, my lord. At 271.
Yes.
Now the lordships may skip, my lord, the earlier para, last 3-4 lines. It is true to say that democracy, people are sovereign. All powers belong primarily to people. The retention of such power by the people and the
That's true. These are well.
lordships.
We've read them.
Now, my lord, 103 is how the states are formed on the basis of linguistic, ethnic, and
That's
other
all,
things,
yes.
and that cannot be disturbed.
Yes.
Lordships were noted. That's enough, my lord, for me. Now, the only thing is, my lord, that in the book, Justice Anand, my lord, says that as far as the sovereignty is concerned and autonomy, they are, my lord, interchangeable terms, that what you call sovereignty is autonomy. Now, that is, my lord, something which is important when we say whether there is autonomy in the form of sovereignty with the people, and ultimately in the Constitution of Jammu and Kashmir. Now, my lord, with regard to the interpretation of 370, lordships have read it number of times. I just wish to point out, my lord, two things. One is, my lord, when we look at 371B and, my lord, 370D first proviso. These, my lord, two provisions, they talk about the consultation. Rest is concurrence. So my argument is, my lord, as far as the concurrence is concerned because the Constituent Assembly doesn't exist. And I must point out, my lord, how the Constituent Assembly of Jammu and Kashmir, because that has not been pointed out, how it was dissolved. There was a resolution, and pursuant to the resolution, it was dissolved. So therefore, my lord, those parts are concerned. The provisions, my lord, in terms of the 1954 presidential order, which has been issued, my lord, I know lordships are probably, if I'm repeating something, then 1954 presidential order, which is there. If you look at the 6 presidential orders which have been issued, the first one is, my lord, consultation. There are other 3 consultation. One is, my lord, CO 44, which is, my lord, under 373, where, my lord, the Constituent Assembly's prior recommendation was taken because they changed the explanation there from, my lord, Maharaja to Sadr-e-Riyasat. So that is, my lord, one thing which shows that ultimately you require prior recommendation of the Constituent Assembly. The only provision is 1954, which talks about the concurrence. My submission is, my lord, that the concurrence ultimately comes to an end because the Constituent Assembly is not there. But the question arises, my lord, which your lordships may put to me, what about the presidential orders which have been issued subsequently? The only answer, my lord, which I think can be given is that all the subsequent presidential orders which have been issued are either some changes, some amendments in the 1954 presidential order. They are not, my lord, because the areas were carved where the union will legislate, and the areas, my lord, where the Jammu and Kashmir constitution will prevail. Therefore, my lord, all those things which have been issued can be justified only on this basis that these presidential orders, because 1954 presidential order was issued after, my lord, the concurrence of the Constituent Assembly or approval of the Constituent Assembly of Jammu and Kashmir. Therefore, the subsequent presidential orders which are issued were under the presumption that the Constituent Assembly's approval already exists, as far as the presidential, this is one way to look at it, because when I tried to find out, I couldn't get any answer, because if the Constituent Assembly comes to an end, naturally the entire, there is no Constituent Assembly, therefore there can't be any concurrence in that sense, which is provided, under 370. I have formulated, 370. I just read, two formulations. 370, I am reading that, provided the constitutional mechanism by which the instrument of accession was integrated into the Constitution of India. Recognized, recognized areas where the Constitution of India will operate, and by respecting will of the people, carved out the areas where the Constitution they wish to give unto themselves will prevail. Second is, 370 is temporary in the sense that it contained the principles which would govern the formation of Indian Constitution as applicable to J&K as well as the Constitution of J&K. Once that was achieved, the aim and object of 370 was fulfilled. Seeing each other, meeting each other was converted into a relationship on mutually decided terms. It is this relationship which is permanent. This relationship could not be unilaterally altered. It is like a constitutional promise embedded in will of the people. With the dissolution of Constituent Assembly of J&K achieving its purpose of giving birth to the Constitution, the temporary provision achieved the permanent result. The other significant permanent feature being that people of J&K accepted J&K with all its territorial limits to be an integral part of India for all times to come. No, my lord. There are three documents, my lord, on the basis of which the interpretation of 370 is possible. One is, my lord, the Constituent Assembly debates in India, the Constituent Assembly debates of J&K, and the judgment in Premnath Call. Now, from all these three documents, my lord, two situations emerge. One is that the Constituent Assembly will have a final say. All, my lord, the debates as well as debate in Jammu and Kashmir, and my lord, the Premnath Call judgment says so. That number one, Constituent Assembly will have a final say, and number two is relationship will be finally determined by J&K Constituent Assembly. These are the two factors which are common, my lord, in the entire thing. I just wish, my lord, because the Mr. Gopal Subramaniam had read, my lord, the debates in Jammu and Kashmir Constituent Assembly, but I just wish to draw your lordship's attention to my submissions. 504, just, my lord, look at 512.
Yes.
These are my submissions, my lord, which is in volume 1 of the submissions, starts from 504. Just kindly come to 512.
Yes.
And then, my lord, lordship may skip. This is, my lord, what Sheikh Mohammed Abdullah makes a statement on 370. The entire paragraph is that. Lordship may skip that and come to, my lord, 514. Just above para 26. The Constitution of Indian Union therefore clearly envisaged the convening of a Constituent Assembly for Jammu and Kashmir state which would be finally competent to determine ultimate position of the state in respect of the sphere of its succession, which would be incorporated as in the shape of permanent provisions in the Constitution. This briefly is the position which Constitution of India has accorded towards. Now, this was, my lord, the same thing which we find in the debates, my lord, of Gopal Swami Iyengar. He says the same thing we find, my lord, in the judgment of call. And this is what. So there was, my lord, ad item as to what should be the shape and what should govern the relationship between, my lord, Jammu and Kashmir and India. Now, my lord, 26 is, which has not been shown to your lordships, how the ultimately it was dissolved, the Constituent Assembly of Jammu and Kashmir. Now, my lord, this is the statement which was made by Mir Qasim. He said, my lord, whereas the Constituent Assembly came into being for framing the Constitution for the state, whereas the Constituent Assembly has enacted and adopted the Constitution for the state, now therefore this Assembly resolves, shall stand resolved on 26th day of January 1957, which is the date of commencement of the Constitution. Sir, I would like to make a brief submission with regard to this resolution. The resolution aims at dissolving the Constituent Assembly by passing and adopting the Constitution, which will come into force on 26 January. The Assembly has done its primary and main function, and it is but natural that it would stand dissolved. Legally, it could not have been dissolved by any authority because people elected this Assembly for a specific object. Now, the object having been achieved, it is reasonable to dissolve it by way of a resolution. Hence the resolution. This Assembly is not capable of protecting the Constitution. It had only the mandate of framing and enacting the Constitution for the state and nothing more. Now we can skip the entire thing, my lord. And finally, on the next page, the last 4 or 5 lines, Mr. President, the question is whether the Constituent Assembly came into being for framing the Constitution of the state, whereas the Constitution Assembly has enacted, they adopted the Constitution. Now, therefore, this Assembly resolves, it should stand dissolved on 26 January, which is the date of commencement of the Constitution. And we close the business. And then, my lord, after this cross is, my lord, the proceedings on 26th of January 1957. Mr. President, today this historic session ends. With this, the Constituent Assembly is dissolved according to the resolution passed on 17th November 1956. Clock struck 12 p.m. and Constituent Assembly was dissolved by the President according to the resolution adopted on 17th November. I thought I must draw your lordship's attention to this important part, how it was dissolved. Now, my lord, as I have read, my lord, on 370, I am not going into, my lord, the Sampath Prakash and other arguments which I am skipping because all that has been argued. Now, lordships may only look at one part, 2 parts actually. The presidential order, my lord, which was passed on in 1954, had expressly, my lord, excluded Articles 356, 357, and 360. Kindly look at, my lord, lordships have seen that, aware of that. That is volume 3, page 18. Now, these were expressly excluded, and because they were excluded, it was with the understanding that as far as there is a breakdown of constitutional machinery in Jammu and Kashmir, then ultimately it will be taken care of under the Constitution of Jammu and Kashmir, and they brought in Section 92 for that particular purpose. Now, thereafter, my lord, and this was with the concurrence, which, my lord, my argument, if it is accepted, then after that, no change was possible because 92 had already come into operation, which took care of the entire situation. Now, 356 was brought in by virtue of CO 71 in 1965. Now, lordships will mark it. This is page 37 if you lordships want to see volume 3. Now, 357 was not adopted. 357 was not brought into. It is only 356. So one question which arises is, we have to, my lord, question that what is the implication ultimately of 357 not being there? I hope I am clear, my lord. If your lordships want to note down the pages, I can.
Yes.
No. My lord, that 54 presidential order, just show me that. Otherwise, what I'm trying to not point out is this, that the Constituent Assembly of Jammu and Kashmir,
At that time,
finally,
356
when
was not-
the, finally the
356 was
situation.
not, 356 was not there. Subsequently, 356 has been made applicable.
No, Milord, what I'm trying to say is, I can show the debates. When 92 was inserted, section 92, what were the debates, Milord, in the Constituent Assembly of Jammu and Kashmir? What I'm trying to show is the Constituent Assembly of Jammu and Kashmir ultimately approved that 356, 357, 360 will not be there. And therefore, Milord, 92 came into being. So 92 provided for the situation because 92, equivalent of 92 doesn't exist for as far as other states are concerned. Thereafter, Milord, the changes were made, and in 1965, 356 was inserted, brought in. Said wherever constitution is mentioned, you read it as Constitution of Jammu and Kashmir. 357 was not brought in. Now, if you look, Milord, read 356, it says that you give parliament ultimately or to the president. Under 357 alone, that the orders can be passed or law can be made. Can you look at 357, Milord? This will also have a bearing on Milord section 3, but I am not going to those parts. Now, 357 says, whereby a proclamation issued under clause 1 of article 356, it has been declared that power of the legislature of the state shall be exercisable by or under the authority of parliament. It shall be competent for the parliament to confer on president the power of legislature to make laws, authorize the president to delegate, subject to such conditions as he may think fit, for parliament or the president in whom such powers are vested to make laws conferring powers for imposing duties. I'll take your lordships, Milord, through the Governor's Proclamation 92.
Article 357 has not been made applicable.
It has not been made
And
applicable.
therefore, though Parliament can assume to itself the power of the state legislature to enact laws,
Yes,
you cannot further delegate it to the president.
correct. You cannot do that. That's not my argument. And kindly, Milord, see the proclamation which was issued on 20th of June 2018. Just look at that, Milord. That proclamation, Milord, is at volume 3, page 85. I am saying, Milord, that there is a machinery which existed to take care of the constitutional breakdown. And I am quoting again Justice Anand's book because he says, relying upon number of judgments which are given by, Milord, the Jammu and Kashmir High Court, whether it is, we can reconcile both. And the argument is, yes, we can reconcile. But the question is, ultimately 92 acts in a particular sphere and 356 acts in a different sphere altogether. You can reconcile, it can exist. But the question is, they operate in different fields. And once you exercise power under 92, and you say we are dissolving, and look at, Milord, this particular proclamation, which is, Milord, at page 85. Just look at it, Milord, in 92. And I'm asking myself why 356 was not issued initially. It could have been done. Why they resorted to 92? An answer will also come, Milord. Answer is because after the proclamation, on the next date, he dissolves, Milord, the assembly by resorting to section 53 2B, which could not have been done without the aid and advice of the council of ministers. Why it was done, Milord? Because it is dissolved, and then you take over ultimately. Now, proclamation, Milord, says powers conferred by 92, enabling me in that behalf the concurrence of the. Now, one important factor I must mention. I'm so sorry, I have to hurry up, my lord, otherwise necessary for me to show, but because lordships are aware, I'm going on that basis. Section 92 says, my lord, concurrence of the president. So naturally, when this proclamation was issued, there was proclamation, it says so. There is a proclamation of President of India. Now he gives, my lord, the concurrence to the proclamation which was issued, the president. And after that, my lord, certain provisions are suspended. He says any reference to state constitution or acts or made by the legislature shall be construed as including reference or acts made by me. That is on page, my lord, para 5. In exercise of powers of legislature of the state under the proclamation made under such and such. So assumes, my lord, on that date itself, the powers to make the laws. Now, my lord, look at this one and 357. How you reconcile both the things. And next day, my lord, he says power vested upon me under 92(1), exercise of powers under 53(2)(b) of the Constitution, Jammu, I hereby dissolve the Legislative Assembly. Now, 350, section 53(2)(b). If we read, my lord, section, I think 35, that this can be done. 92 you can exercise without the aid and advice of the Council of Ministers, but 53 you cannot do, which is necessary. So he does, my lord, a thing which is absolutely unconstitutional act. It was impermissible to do it. But my argument here is, if you lordships, my lord, I can give certain, there's a discussion by Justice Anand in his book about how these two provisions can work in Kashmir. That is volume 17, PDF, my lord, at 143, 144. What is it? So, my lord, my submission is, in this situation, it was not permissible for the President, my lord, to invoke the powers under 356 because under 92, and 92 is something which was approved ultimately by the Constitution of India and also the Constitution of Jammu and Kashmir. It's a malafide, excess of power, and a fraud, which, my lord, I don't want to go into the judgments. Now, my lord, my probably last, I must say, argument is with regard to CO 272 and 273. Just kindly have a look at, and the argument will be very brief. Kindly look at, my lord, 272 at page, I think, PDF 101. Lordship had put a question to Mr. Sibal. This is 5th of August 2019. And 6th, my lord, is the final order which has been issued, CO 273. I must say, my lord, before I go to 272, is that 273 assumes, my lord, the fact that the prior recommendation of Constituent Assembly is necessary. If we understand that way, my lord, then kindly look at it. It means if you want to make any change in 370 as such, which we draw, my lord, from CO 44, which I pointed out, where you change the explanation. That's the only thing, my lord, which the Constituent Assembly approved. Now, here, my lord, what they do is that through the interpretation clause provision, they, my lord, indirectly change 370 itself. Kindly look at, my lord, this one. To 367 shall be added the following clauses. Lordships may skip A. A says construed as references to such and such. B is references to person for the time being recognized by President recommendation of Assembly. Sadr Riyasat, acting on advice of Council of Ministers of State for the time being in office, shall be construed as references to Jammu and Kashmir. Now, exactly the same words which are used in the explanation. So they are changing, my lord, the explanation without the prior recommendation of Constituent Assembly. And look at, my lord, below that. In proviso D, 3 of 370, expression Constituent Assembly of State 2 shall be read as Legislative Assembly of the State. Now, my lord, I ask myself that how this is possible that you can change 370 as such by virtue of the interpretation when you recognize in the very next order which was issued that Constituent Assembly's prior recommendation is necessary. So this interpretation, my lordships are asked, why this interpretation? Without this interpretation also something was possible. This interpretation was resorted to because they wanted to show the exercise ultimately done by them by CO 273 is something which is constitutional in nature. That is to say that they have done this thing after prior recommendation of the Constituent Assembly. So how they may not achieved it, they changed 370 to the interpretation clause. Absolutely, my lord, unconstitutional act. And after doing this, I hope I am clear, my lord. After doing this, then, my lord, the final order is given. What it says, CO 273. In exercise of powers conferred by clause 3 of 370, read with clause 1 of 370 of the Constitution, the President, on recommendation of Parliament. So, my lord, the recommendation of the Constituent Assembly after that was substituted by recommendation of Parliament. Is pleased to declare as from the such and such all clauses of the 370 shall cease to operate. So what they do is they know without Constituent Assembly they cannot do. Constituent Assembly is not there. They bring in through that interpretation indirectly. And my submission is what you cannot do directly, you cannot do indirectly. That's again a fraud on the Constitution. Lordships have followed, my lord.
This argument has been raised.
It was, I am so sorry, because I think I was attending all the, in this, because Lordships have put a question to Mr. Sibal, what's the meaning of this interpretation clause? Why they resorted to interpretation? They resorted to interpretation because they could not have done directly with 370. Therefore, they resorted to, and after making change, came out, my lord, with this one, on the recommendation of Parliament. Now, other question, which is a prior recommendation. According to 373, it is prior recommendation of Constituent Assembly, it has to be prior recommendation. Now, kindly look at, on 5th of August, this notification is issued. How, my lord, next day, a prior recommendation of Parliament was sought. On the face of it, my lord, it looks obvious that this is something, my lord, which is not permissible. The entire exercise, my lord, shows that it is mala fide in nature. So therefore, my lord, this goes, 272 goes, the other, my lord, proclamations which are issued, they also go.
Thank you, Mr. Parikh. Thank you.
I mean, it becomes very difficult sometimes because I know, because you read a lot, chip by chip, my lord, things are removed. Few chips remain, my lord, then you have to sustain yourself on those chips. So probably I do not have done whatever.
Thank you, Mr. Parikh. It's the same.
Not more than 7-8 minutes.
Yes.
Fast as possible. Now, just 3 points I want to highlight. Proposition being a more restrictive and strict approach in interpreting Article 370 for 3 reasons. I'm taking the broader view because the nuts and bolts have been gone into. The first reason is historical. The second is jurisprudential. And the third is in terms of the constitutional ethos. The historical part, my lord, which I'd like to emphasize for a more restricted and strict interpretation is that the region consisted of a Muslim majority. And the population, my lords, had a choice between either going into Pakistan or into India, either being a majority in Pakistan or choosing to take a minority status in India. My lords, it chose the latter. And my lords, although the historical part has been dealt with about the signing of the instrument of accession, just a few pages I'll highlight to show how it was Sheikh Abdullah who represented and who had a hold over the population at that time, who was responsible for this transition to India. And therefore, my lords, one of the important points which I'd like to make is that if there is a choice, a conscious choice made to remain a minority in a region in the backdrop of the horrific violence of partition, my lords, when there's a constitutional promise in the nature of Article 370, it should be strictly construed. That's my first point. And my lords, in regard to that, my lords, may I just point out 2-3 pages, VP Menon's book on the integration of the nation state. I'll just point out the pages so that I don't take time. My lords, page at volume 15, PDF page 1258, where it just mentions that Sheikh Abdullah rose to power to fight for the rights of the Muslim community. By 1939, the body had shed its communal complexion and changed its name to National Conference. He had a considerable hold over the people of the state. That is BP Menon's book at page 1258. Then, my lords, may see page 1259 PDF. The Maharaja was assured by Lord Mountbatten that if he acceded to Pakistan, India would not take it amiss, and that it had a firm assurance of this from Sardar Patel himself. Lord Mountbatten went on to say that in view of the composition of the population, it was important to ascertain the wishes of the people. This is PDF page 1259, volume 15. The situation for the Maharaja was not easy. This is again Menon pointing out. If he acceded to Pakistan, the non-Muslims of Jammu and Ladakh, as well as considerable section of Muslims led by National Conference, would have resented such an action. That is page 1259, PDF page 1259, volume 15. The government of India had no territorial ambition in Kashmir. If the raid by the tribes had not taken place, government of India would have left Kashmir alone. That is at page 1271, PDF, volume 15. The tribal invasion was not a spontaneous affair engineered by Pakistan. That is at page 1271, volume 15. The accession was legally made by the Maharaja of Kashmir, and this is important. And the step was taken with the advice of Sheikh Abdullah. That is PDF page 61, volume 20. This is A.G. Noorani's book. This is not, up to now I was stating Mr. Menon's book. This is A.G. Noorani. And then, my lords, may see on 27/10/1947, in reply to the request for accession by the Maharaja, the Governor General of India, Mountbatten, clearly stated that the issue of accession should be decided in accordance with the wishes of the people as soon as law and order had been restored in Kashmir. This is PDF page 59, volume 20. In the context of these historical facts, both Nehru and Sardar Patel were of the clear view that Jammu and Kashmir should decide their own consequences. See letter of Jawaharlal Nehru dated 18th of March, 1949, PDF page 67, volume 20. This is again A.G. Noorani's book. It is in this context, my lord, that 370 emerges. So, my lords, my first submission is this, in this context, that when there is a conscious choice made in this manner, my lords, all the more reason why it should be taken strictly. And in this context, may I just point out S.R. Bommai at page 218, PDF page 218, volume 2, which says that federalism is not seen merely as a matter of administrative convenience, but one of the principal outcomes of our own historical process and a recognition of ground reality. And, my lord, this leads to what is called asymmetric federalism, my lords, which has been extensively dealt with by my lords in the NCT Judgment 2. It is also, my lords, in fact, one of the first persons who coined the term asymmetric federalism in the Indian context was Professor Balbir Arora from Sorbonne, and he was also the professor for political science in JNU. And his book, my lord, which is at page 242 to 243, PDF page, volume 17 of the document compilation, where he talks about the nature of asymmetric federalism, which was there, which is to take into account different regional aspirations. And it has a remarkable degree of flexibility and pragmatism. It is a calibrated institutional response to the diversity of constitutional unit permeating both de facto and de jure variation. My lord, thereafter, my lords, may I just point out the above fact that it is an anti-majoritarian or a protection against majoritarian that asymmetric federalism provides. And in that context, my lords, our constitution is also a anti-majoritarian in many ways, my lords. There are lots of judgments which have dealt with it. I put it at point E.3 of my written statement at page 500. That is E.3 of my written statement. Then, my lords, Keshavan Bharti case at para 208, PDF page 151, volume 15, where I point out that where it is emphasized that in case there is a it quotes, my lord, the case, and I'll just quote it. I may mention that the Judicial Committee, while interpreting British North America Act 1867, had also kept in mind the preservation of the rights of minorities. For they say in the regulation and control of aeronautics in Canada, the British North America Act embodies a compromise under which the original provinces agreed to federate. It is important to keep in mind that the preservation of the rights of minorities was a condition on which such minorities entered into the federation and the foundation upon which the whole structure was subsequently erected. The process of interpretation as the years go on ought not to be allowed to dim or whittle down the provisions of the original contract upon which the federation was founded, nor is it legitimate that any judicial construction should impose a new and different contract. This is echoed in Jindal Steel case at 2017-12 SCC 1, that is PDF page 219 to 220, where it is very clearly pointed out, again, it reiterates Keshavnan Bharti, that the original terms should not be whittled down. And so, my lords, the argument that so-called hollowing out of the Article 370 through various orders which have taken place. Already Mr. Nafre has argued that there was no hollowing out, the core remained. But assume that there was a hollowing out which takes place. It is a political act. And my lords has been very clear in this entire proceedings that we are interpreting the constitution. So if because of a political act, there is a so-called hollowing out, which is without prejudice to that argument, I do not accept that it is. But if there is such is the case, even then that should not affect the interpretation of the provisions of Article 370. Then, my lords, Podwal case again highlights the aspect of asymmetric federalism, which I will not go into. My lords, the second point, briefly, what are the limits, my lords, if you're looking at the broad approach, what are the limits by which we will determine what are the limits of a constitutionally vested power? And my lords, the answer is the analogy of Mill's famous thing on liberty, that your liberty ends where the other man's nose begins. So the moment there is a fundamental constitutional principle which is there, which is getting affected, the limit must be there. And my lords, in that context, the NCT judgment case, there are 2 pages I'll just point out, PDF page 92 at para 108, volume 5, and PDF page 35 at para 40, volume 14. My lords, also there is the Miller case, that is at PDF page 324 of volume 5, recent Miller case in the UK, in the context of proroguing of the House, where again this concept is put forward. So it's an international constitutional concept, which is also equally applicable here. It has been reiterated by various judgments in India. My lords, I would also urge that if we are talking about minority rights, if we are talking about anti-majoritarian or protection against majoritarian, my lords, there is the LGBTQ plus judgments, etc., which are coming. There is an evolution which is taking place. With respect, my lords, this kind, if one were to do away with this thing which involves historically a religious minority, not that they are necessarily expecting, if that is there, my lords, it will be a regressive step. And my lords, in line with what is happening, in line with in which the evolution is taking place, more and more inclusiveness is there, it should not be there. I'd like to finally end, my lords, I won't take more time. I'd like to end by pointing out 1 or 2 quick points. One is, my lords, in our rejoinder at page 88, the Niti Aayog report is there. Now, my lords, there is no material which has been brought on why 356 was imposed. My lords, that has always all been argued. But the material of the government, which is already there on record, it says in peace, security, effective governance based on rule of law and upholding principles of equality, Jammu and Kashmir rises above a number of states. And my lord, that I've put at page 88 at volume 13 of the Niti Aayog report, page 282 of volume 13 at page 286 and page 285. This is prior to abrogation. So my lords, this further kind of deepens the mystery. And of course, there are statements made by ex-constitutional authorities, not of much relevance now that he's not holding a constitutional post, but how it was exercised. But when this was the case, if Kashmir was a leader, it's used as a leader in these areas, where was the need for a 356? My lords, finally, one last anomaly which my learned friend had also pointed out, and that is, I'll just point out that in volume 3. Sorry, my lord, just a minute, just on the reorganization. I'm sorry. Yes. My lord, we come to section 57. My lord, it's the botched up kind of situation which is arising now with this. Of course, the Reorganization Act is consequential, I understand, but still, my lord, I may just point this out. 57 at PDF page 126, volume 3. My lord, it says, notwithstanding anything to the contrary, contained in any law, document, judgment, ordinance, rule, regulation, or notification on and from the appointed date, the Legislative Council of the existing state of Jammu and Kashmir shall stand abolished. On abolition of Legislative Council, every member shall cease to be, etc. So it abolishes the Legislative Council. Now, my lords, what is peculiar is, just before this, the CO 272 is passed. CO 272 applies all the provisions of the Constitution. When you're talking about abolishing the Legislative Council, then it has to be as per section 169 of the Constitution of India, which is already stands applied on pursuant to CO 272. Once that is applied, then my lord, what happens? It can't be done away by way of this act. So we've already challenged the validity of this act, but my lord, this is like a Trishanku Legislative Council, which has not been abolished by any proper procedure which is prescribed by law. So my lord, that was the point, and there was one more. 73, my lords, is that, my lords, clause which has come even by way of amendment in the context of the Delhi government also, that if the president on receipt of a lieutenant governor, my lords, the same powers as 356, but no time limit provided. I'm very grateful, my lords, and I'm extremely grateful that my lords had this the technology which enabled us even many times, even while we were not present in court, we could keep in touch with the deeply obliged.
Yes, Mr. Ramakrishnan.
One of the major political parties and was heading the government at the time of governor's rule, and I have held office. I've formed the government twice before. I was a single major party, and I'm therefore, I would venture to suggest, much more representative of legislative will than that ersatz and duplicitous reference in CO 272 to the Legislative Assembly. I also represent writ petitioners in writ petition 1099, where Mr. Ramachandran was appearing, petitioners 3, 4, and 5.
I want to make a submission with my.
As far as I'm concerned, I appear for PDP. I don't
Who are
know
you?
what this is.
Who are you?
Who are you?
This writ petition 1099 was initially filed by 6 people. Then 2 of them withdrew, Dr. Shah Faisal, and then.
I don't know what he's talking about.
Then the writ petitioner number 1, who is Mr. Javed Bhatt. Javed Bhatt, when he engaged my learned friend, then the understanding senior counsel Raja Ramachandran would be arguing the matter. When he came to know that he has withdrawn from the matter, then he contacted a senior lawyer from Kashmir, Mr. Muzaffar Hussain Beg, who in fact.
I didn't know anything of this. I'm sorry. Let me represent PDP, the impleadment application. My lords will hear him whenever it's done.
We are not PDP.
Yes, I'm arguing for PDP now. My lords will hear me.
That's an intervenor application, but the mandate petition, Farooq Bhatt is the petitioner number 1. When he engaged them, then the understanding was that Mr. Raja Ramachandran would be arguing the matter. When he withdrew from the case, then Javed Bhatt, petitioner number 1, he approached Mr. Muzaffar Hussain Beg. So we have filed the Muqaddimah that perhaps not has been placed on the board because of some timeline issues.
May I clarify?
That petitioner number 1 in writ petition number 1099, Mr. Muzaffar Hussain Beg would be arguing, of course, with the permission of my lords.
See, ordinarily there's no difficulty, but normally for all of the entire group of petitioners in a petition, you presume that they are sailing together. Therefore, one lawyer would appear for all the petitioners. For different respondents, different lawyers can appear. But for people who join together in a petition, if there is some conflict within the petitioner, somebody has to get transposed or file another proceeding.
That conflict arose because of the grant of Mr. Raja Ramachandran.
May I make a clarification, Your Lordship?
Just for factual clarity, writ petition 1099 was filed by how many people?
By initial. May I?
Just one second. He's in charge. 1 second. Yeah.
I instructed in the matter, Your Lordship. There were initially 7 people.
Yeah.
Of which Dr. Shah Faisal and Ms. Shaila Rashid had subsequently withdrawn. Mr. Ramachandran, in fact, argued their applications for withdrawal, and this was allowed by this court.
So we're left with 5.
There were 5. There was one Mr. Javed Ahmed Butt, his was petitioner number one, who became the petitioner number one after Dr. Shah Faisal's withdrawal. So last evening, I received a request saying that there has to be a way in which we had another arguing counsel with the team. And this was because this was contrary to the express orders of the court, where it had said that all the petitioner's arguments had to be wrapped up today, and that a certain list was had. So and therefore I deemed it unreasonable to accede to that request at that time, and I had indicated that they are free to pursue their remedies, whatever they have, and they had therefore requested no objection. On which I had a separate, very detailed release covenants that I had in fact received from the petitioner, where in the detailed release covenants he had covenanted that these hearings would not be interrupted, and after the hearing plan is over, if anything, with the permission of the court, he may take that is because as also the nodal counsel, we owe duty to the court that
Just 1 second, 1 second. Jadara mic band karo.
I don't want to appear for anybody in this writ petition. I will just appear for PDP. Yes, I don't want to appear for him. Uncouth to interrupt.
In the petition which you are arguing, it is 1099. You are the first counsel to argue, right?
Yes, because Mr. Ramachandran requested me.
Right. In the last 3 weeks, you are the first person who is arguing this matter.
Correct. Until yesterday, I thought I was arguing for all the petitioners. But I'm happy to please keep quiet. I'm arguing for PDP definitely.
Yes.
And let me argue for them. If my friend who he represents in that petition, I don't.
Now, Mr. Counsel, what you are suggesting is that Mr. Muzaffar Hussain Beg will appear for Mr. Javed Butt.
Yes, ma'am.
Now, you see, there's only one difficulty. See, we want to be fair. We don't want to shut out any voice. It's our duty to give a fair hearing to all perspectives. At the same time, you're also conscious as a member of the bar that in a petition, when a group of petitioners have come together, one lawyer appears for all the petitioners. There may be a little conflict or diverging interest between respondents, and therefore respondents are entitled to have separate representation. But at the same time, we are more than willing to hear Mr. Beg's perspective. The way to do it is then Mr. Javed Butt will perhaps have to withdraw from that petition 1099, and we'll permit Mr. Beg to make a brief representation as an intervener. We can do that. Ultimately, it's a question of yours of being heard by the Supreme Court, isn't it?
So and she has very gracious.
So, Ms.
She has very gracious
Ramkrishnan,
that she would be representing the only.
Ms. Ramkrishnan, now the remaining 5 petitioners in 1099, who are those 5 petitioners? Is PDP party in that? Just 1 second.
PDP is an impleadment application. She is an impleader. Because she was in jail. She was in imprisonment when all these petitions were.
Her application is for impleadment.
Yes.
As a petitioner.
Yes.
But the others have to agree to her impleadment.
They have agreed. They have no objection.
Not impleadment, not for as petitioner, my lord. She wants to be impleaded.
Correct.
Who represents the other four? One of them, that this is a new development, but
Just one second, one second. Who's for the other four now? Or the other five? Because actually there are five now left.
Shah Faisal withdrew.
And likewise, Ms. Sheila Afridi withdrew. Now who's appearing for the remaining five?
Was stated to appear now until this.
Ms. Ramkrishnan, are you appearing? Forget Javed Bhatt's case for a moment. We'll say the remaining four. Apart from appearing for the PDP, are you representing the four as well?
I was given to understand that until this minute.
But even at this minute, he is
I
representing.
represent it. If
So we take it apart from the impleader, intervener, which is the PDP. You are appearing for the remaining four, and you have instructions to appear for them by the advocate on record. All right. Now, insofar as Mr. Javed Bhatt is concerned, we will. What we'll do is we'll complete the submissions of Ms. Nitya Ramkrishnan. Rest assured that we will give a. Let's see how things progress. All right. We got the point now. Yes. Yes, Mr. Ramkrishnan.
I'll try and speak in bullet
But then
point.
only one thing. Do we take it that you, Mr. Javed Bhatt, seeks to withdraw from this petition so as to allow him a separate intervention?
No, he is not withdrawing as a petitioner.
But then if he is not withdrawing as a petitioner, we are trying to create some space for you. If he is not withdrawing as a petitioner, then the advocate on record will appear for him. How can you have a different counsel appearing?
Because he has obtained an NOC, and the reason as a.
when did you obtain
When did you obtain the NOC?
Very respectfully, I submit.
When did you obtain a NOC? Please tell us.
Yes, my lord. Then
You can't do that.
The matter on the last date of hearing, you obtain a NOC. Then you say, now I want to appear for that one individual petitioner. He will continue to be the petitioner, while four others or five others are represented by another council. Because background or no background, we are not.
This we will not
background
permit.
much earlier.
In any case, one thing is very clear, even in a normal civil appeal, we will not permit people to withdraw in the course of a submission. And not when a matter has gone on for 3 weeks. This we will not permit.
my submission.
We will, please understand the position in law. We will go strictly by the position in law. We will give you an opportunity, should Javed Bhatt not wish to continue any further with Ms. Ramkrishnan's petition, no difficulty, we will permit him to delink himself and we will give him a separate hearing. But he cannot be a part of that petition and say there will be two lawyers arguing for them, because there may be a conflict of arguments on that, which is not permissible in a petition. We saw that, for instance, Mr. Dwivedi adopted a different line, but he couldn't do it because he was in a different petition.
And as I submitted, I beg to reiterate, Lord, the situation arose only when Mr. Javed Bhatt came to know that Mr. Raja Ramachandran is not arguing the matter.
But that was so for the last 3 weeks.
Yes.
Everybody knew that he is not going to be appearing for the last 3 weeks. He didn't appear.
Was not appearing in the list.
Well, on the first hearing 2 years ago, he opened the argument. 3 of us were party to the bench. He is the one who had opened the argument. Now it was said thereafter that for whatever reason, Mr. Sibbal now started it. He was not available. Now suddenly in the last date of hearing, at the last nth minute, you say, not only at the nth minute you interrupt and say, well, I want to sail in some other boat.
She's running for submission.
That he had for the because
We'll argue sensitive, otherwise.
All right, we'll cut through all this. Above all, we are absolutely sure in our mind that we want to give an opportunity to different perspectives, because we have to be duly apprised on all sides, different perspective, different points of view. As we said, even within the petitioners, there were different shades of constitutional argument. We'll not shut anybody out. We will hear, but let's follow the correct procedure in law. Let's not set down procedures which are wrong. Mr. Attorney General, we'd like your assistance on this. Forget now that you are. Will that be a proper procedure, Mr. Attorney? I think so. Yes, Mr. Ramkut.
All this happened to me. Please, if I may just, I don't know who to.
I gave only purpose of thinking on something.
Mr. Beg, please rest assured, we'll hear you. No difficulty at all. Please be in the court, Mr. Beg. Mr. Beg, you can be in the court. You don't have to leave. You can be in the court now. We'll hear you after. You can be in the court. Yes. Please ask one of the juniors to give a chair to Mr. Beg so that he can sit down. Yes. Yes, Ms. Ramkrishnan.
I'll try to make my arguments in bullet points, so I'm quick. The first point I wish to make is that integration is neither a linear concept nor a quantitative concept. There is a spoken and unspoken assumption that Article 370 is temporary in anticipation of some greater integration.
It's neither a linear concept
nor a quantitative one. My friends on the other side.
Yes. Looks like we'll go on to the lunch. Since we are 6 or 7 minutes short of 4 o'clock, and there's an event at the bar in the evening, otherwise we could have continued till 5:30. You are going to argue on Article 356.
No, I was going to argue on integration, shared sovereignty, and the political context in which this happened, because it's directly relevant to our judging it.
Let me suggest one thing. Can you put down what you really have to so that it brings clarity to us? We are also at the end of the argument, so there's a tendency to be just jaded by the length of submissions. If you can put everything down on one page, just formulate exactly what you're, and then, for every submission, you can cover yourself in about 2 minutes so that we have some clarity on what you're arguing.
That's what I have in mind, but
fair enough.
Want it in writing?
Just a page or so. Just give us a page. No, give it to us tomorrow morning. A page.
Tomorrow morning.
Now, Dr. Guruswamy, on delimitation, we are not going to hear this because delimitation is not an issue at all which arises here.
It was challenged and it is confirmed by this honorable court.
Justice Call's judgment, yes.
My Lord Justice calls it.
On internal sovereignty.
Sovereignty, not repeating any argument.
And not on delimitation.
That's
likewise. So what we'll do is, we'll likewise request you to formulate your points on just a page on internal sovereignty, right? Then Mr. Manish Tiwari, what would you be arguing? You are going to Northeast, how can we hear it in this matter?
Follow to abrogate 370 and bring about the reorganization of Jammu and Kashmir and its implications qua the Northeast, because 370 is succeeded by 371 and there are asymmetric guarantees which were given, and those guarantees have implications on national security because the Constitution, while being a legal political document, also performs a very important national security function in terms of integrating the periphery and the rest.
So let us formulate it like this. What you want to really argue is that the impact of the argument which would be propounded by the other side on other similar provisions of the Constitution.
What Your Lordship,
similar provision.
Respectfully, what I want to submit is that there is already a process which has been adopted by Parliament in terms of abrogating 370. So therefore, there's a precedent in place. And that precedent has implications qua the other guarantees in the Constitution, especially with regard to the northeastern state. So those are the implications which I would like to point out, and I would not take more than 15 minutes of your time. And I assure you, it would not be a waste.
Likewise, what we would suggest is if you can put it down on this evening on a one page,
I would do that.
Then we'll have clarity on exactly what the focus is. All right. Then what about Ms. Farasat?
Malice in law, it's a point for anyone. And one proposition is has been asking, clarifying, and a quick point on federalism.
All right, Ms. Farasat, you can also reduce what you have to say on a piece of paper, on a page.
Yes, I'll do that.
And where's the nodal council? By the evening, please put together all this and give soft copies to the court master, what we are now proposing to do. Then what about Mr. Irfan Lone?
Yes, Lordship.
You're for the intervener?
Very briefly, I will not.
You're on federalism.
Federalism, rule of law, and
Fair enough. Just
democracy.
fair enough.
Because
Just,
that is the soul of the constitution.
absolutely, no difficulty.
It was not followed in
Just the modalities. Put it down on a sheet of paper so that we'll have clarity on what you're arguing. Because now we have had arguments before you, so we'll know exactly what is it that is different that you are arguing.
This lordship, we are given only 10 minutes, so within.
Dr. Z.A. Bhatt. Now, malice in law is being argued by Varisha Farasat also.
Researcher in 370, there is something very important things which have been left out.
All right, one page, you can please put it down on paper on a page this evening and give it to the nodal council. We'll hear you for 5 minutes or so. And finally, Mr. Gopal Shankarnarayan.
Tell your lordships candidly.
Now, what we'll do is this. We'll come back to you.
Yes.
Mr. Ramakrishnan, we'll give you 10 minutes tomorrow to formulate. Dr. Guruswamy will give you exactly 10 minutes to formulate tomorrow. Mr. Tiwari will give you 10 minutes too, once you put it down on paper. If you can all circulate it to the court master by 8 o'clock this evening, we'll all have an opportunity to read what you have written by early morning tomorrow. And then everybody else, after Mr. Tiwari, Varisha Farasat, Irfan Lone, and Z.A. Bhatt, we'll give you 5 minutes each to conclude your submissions once you put it down on paper. Then the cutoff is lunch.
Minutes, Lordship. Lordship,
Mr. Shankarnarayan, after they have all concluded, we'll give you the wrap-up word on the.
Lordship, the earlier list indicates the 10 minutes. So.
You know, time is over already this evening. We have already permitted. So Gopal, be ready tomorrow. We will hear you, Mr. Beg, if you can give us likewise, say by 8 o'clock today, a note not exceeding 2 pages on what your line of submissions is. Please have the note circulated to the nodal council, who is just to your right here, next to Ms. Ramakrishnan, so that that note will be circulated to all the members of the bench by tonight. But do put down what you have to say on a note in 2 pages. And we will hear you right before Mr. Gopal Shankarnarayan. So now the order will be, Ms. Ramakrishnan is in session of the proceedings now. Thereafter, Dr. Guruswamy, Mr. Manish Tiwari, Ms. Farasat, Mr. Lone, Mr. Z.A. Bhatt, then Mr. Muzaffar Hussain Beg, and then Mr. Shankarnarayan. Do you want to hear Mr. Beg before Asuna? So much before we rise for the first session, I think we'll be through with this side tomorrow morning.
What did you say?